na 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 no. Killa me the no. Na 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 no. Killa me the inside. Killa me the no. Just make a boy know you not blow inside. Killa me the no. Nobody ain't got no secret for you about inside. Killa me the no. Just make a boy know you not blow inside. Killa me the no. Tell them say Vegas say so. Me want you skin your teeth and make me see it. If you're sure from your band, say you never tweet. You wanna freak, a one man you keep. And him never yet complain, say you're deep. You make your phone, you no answer to you. And a one man a sample your toe. Need a pro, and make a guy know. Say if he moving blow out, and kill him with the inside. Kill him with the no. Just make a boy know you not blow inside. Kill him with the no. Nobody ain't got no secret for you about inside. Kill him with the no. Just make a boy know you not blow inside. Kill him with the no. Tell them say Vegas say so. Me want hear you scream if your mouth clean. No man never rub your in for no ice cream. You no smell green like Charlene. You all appreciate your healthy hygiene. Some assuming while you keep blooming like a pretty little lily in the morning. You're not crawling, pressure them darling. When you're rising they keep falling. So kill them with the inside. Kill them with the no. Just make a boy know you not blow inside. Kill them with the no. Nobody ain't got no secret for you about inside. Kill them with the no. Just make a boy know you not blow inside. Kill them with the no. Tell them say Vegas say so. Me want you scream, rock out, wind up your body. And inna the air from you and a red ray. One ship alone can talk on your bed. And a boy mic and no DJ. So kill them with the inside. Kill them with the no. Just make a boy know you not blow inside. Kill them with the no. Nobody ain't got no secret for you about inside. Kill them with the no. Just make a boy know you not blow inside. Kill them with the no. Tell them say Vegas say so.
What's up? Let's do it. Been a minute, but I'm back with that rap shit. The mixtape flow, you can find it on that piff. And everything I do for real practice. I don't dance in the booth, but you know I be snapping. Hold up, yeah, I'm going ghost in the burbs. I get paid for my words, all my nouns and my verbs. These labels wanted a hit, I'll hit them right where it hurts. They said the radio don't like it when I curse, but fuck it, I'm coming right back. Okay, you knew that I will. Got a sound, been around, and they doubted me still. I used to be the kid in college that was busy with music, but fuck it, I done graduated, dog, and look what I'm doing. Okay, I think I found a song that you like. Yeah, I found it on a blog last night, and it's new and it got a lot of views. So I'ma cue it up and I'ma show you what it sounds like. Okay, I ain't tryna drive, I'm tryna ride along. So give me your phone and let me play a few songs. And you ain't gotta know them, just fake it and play along. What else am I to do when I'm sitting shotgun with you? Man, I'm a shotgun DJ, same song replay. Big Pun, Outkast, 3 Stacks, Kanye. The radio ain't got a thing on a playlist, so thanks for letting me play this. Okay, I grew up with Ye, and I look up the chance. I'm tryna listen to Thugger, bitch don't fuck up my plans. And if they want it, I got it, I'm gon' meet they demands. I do whatever I want, you do whatever you can. Okay, now go get your mans, I heard he been on the chicks. I mean a few times, fine, but he stay on the chicks. Oh yeah, okay, I'm so photogenic, I send a selfie to your bitch with my homies all in it, somebody take one. Okay, this shit ain't no regular. Not busyness and don't hit up my cellular. I keep it close knit. Okay, I don't know what to tell you, bro. I know you got a jump start, but I'm so far ahead of ya. I think I found a song that you like. Okay, I found it on a blog last night, and it's new, it don't got a lot of views, but I'ma cue it up and I'ma show you what it sounds like. Okay, I ain't tryna drive, I'm tryna ride along. So give me your phone and let me play a few songs. And you ain't gotta know them, just fake it and play along. What else am I to do when I'm sitting shotgun with you? Man, I'm a shotgun DJ, same song replay. Big Pun, Outkast, 3 Stacks, Kanye. The radio ain't got a thing on a playlist, so thanks for letting me play this. Okay, can I get some T-Pain or some 50? Can I get some Usher with some Jeezy? Can I get some Ja Rule with some Chingy? Baby, can I get a request? Yeah, okay, now can I get some Akon with some Nelly? A little bit of Shady and Weezy and R. Kelly. I burn a whole CD for no one but you and me, and it's about time that we spend it.
I wanna make love in this club. R-L-E. Yeah,
Hello. How are you doing? I'm in town. Hey, that's Rule 9D. The Massachusetts Superior Court Rule 9D. Interesting. Grant, my name is Grant Smith-Ellis. Grant, are you in a t-shirt and a suit jacket shepherdizing Superior Court Rule 9D? Yes, absolutely I am. We have things to talk about. Listen, if I'm going to stay up and watch the World Cup, I can't just let my mind rebel at stagnation. I'll go to bed. I get all flustered and mad. Good evening, it's Towel News. We got to talk about a ruling from Judge Gildea. Then I got to yell about mass courts. Then I'm going to yell about other things. How are you all? Sorry, I burped. Good evening. It's about 5:30. And then we're going to figure out what the hell is going on. And frankly, I think the answer is nobody knows what's going on. It's absurd. You can't listen to me. This is like the time we had to analyze whether you could blockade somebody's blockade. All right? You push towel to a certain limit. You know what I'm saying? You can't blockade somebody's blockade. And you can't put an order on the docket saying that you're going to docket the motions, and then the motions aren't on the docket. How am I supposed to analyze? First of all, I didn't even know there was such a thing as a motion going up on the docket and then not being docketed. Second of all, I want the damn motion. How am I supposed to figure out, as an informed, erudite, cogent towel commentator, what the hell is going on? When there's motions that are being referred to in orders on the public docket in the Karen Reed and John O'Keefe civil case that I can't read. How am I supposed to tell people what's going on? So I'm all made. Now, Bunny Towel Mom will tell you don't want to make towel made. Towel gets all made. So we're going to walk through this. We're going to read the motion, the order. It doesn't make any sense. I understand. It makes no sense. I'm not telling you that it makes sense. It doesn't. It's very convoluted and confusing. Then we're going to look at the mass courts docket. Then I'm going to yell about things. Okay? And we're going to make sense of this convoluted juridical nonsense. You know what? This is why Jürgen Habermas wrote his critique of legal rationality. I'm getting all mad. You don't understand. Listen to me. Sometimes I read a note from a judge and I get a little mad. Various reasons. Either I don't like how it was ruled on. Oh, well, thank you for that high five. God bless you, Minx. I don't like how it was ruled on. Or I have some question or something's off. Nope. This is more than that. First of all, I need to calm down because I'm going to get all made. I like puzzles. Okay, they're fun. But that's not how court dockets work. This is not jazz. I'm not supposed to read between the lines and figure out what the judge is talking about. It's not how democracy works. The last I checked, Article 1, Article 3, and the various other branches of the Constitution, the other parts of the U.S. Constitution, the judiciary is part of the U.S. Constitution. I read Marbury v. Madison. I would know. I read the Federalist Papers, too. Anyway, so my point is, if I can't figure out what's going on, okay, I'm sure I'm not going to be the first one who's going to get all made. Other people are going to get made. The news is going to get made. I know we got a soccer game to watch. We're calling it soccer. America's going to beat Belgium. Don't even get me started on the people cheering for Belgium. I'm going to get all mad. You don't know. I'm already mad. Don't make me more mad. You damn commies out in America cheering Belgium on. What is wrong with you? You damn commies. That's my erudite analysis. You're commies. All right, we're going to read this motion. We're going to read this order. Then I'm going to show you paper 127, which at least we can read. Okay, it's now down from the docket. Ironically, the motion that is down from the docket we can actually read because Dee, Super Dee, and I'm sure Kyle, both saved it. Well, it's okay to root for Belgium if you're outside of the United States. But if you're in the U.S. and you're rooting for Belgium tonight, you're a commie. And if you're well, I want to be a commie, well then, what are you doing here? Anyway, my point is, so we're going to read this order, okay? And then we're going to read paper 127, which is referenced in the order. That is not available on the docket, but it is available because Dee Dee posted it on X on June 12th and before it was taken down. Now it's no longer there. So, you know, America. Anyway, then we're going to talk about these mystery motions. Listen to me, I have to breathe. We got mystery men, we got mystery motions. I had to go to the dentist today for a surgery. It was terrible. They stuck needles in towel. Can't just be doing that. I'm already bad. Sticking needles in me. I was so mad. Anyway, so then my point is, we're going to talk about the mystery emotions that are referenced but are nowhere to be found on the docket. They were from July 1st and July 2nd. Nobody knows what these are. They don't really exist anywhere. So I'm just going to guess what they are, okay? Which is not helpful. And it's really important because it's not like this is just Old Man Yells at Cloud, okay? This is not Old Man Yells at Cloud with Judge Gildea. This is like Judge Gildea gave them till July 9th in the Karen Reed civil case, one of 4 civil cases. This is the wrongful death case, which has discovery that ends in August. It's the one where Colin Albert's trying to avoid his deposition, and he went to the army, and then Chloe the dog changed her name, put on a wig, went into WITSEC. She's going to avoid. Can you even depose a dog? I don't know. Somebody asked Alan Jackson. If she were subject to a subpoena, she would flee the jurisdiction. And then, you know, Yuri Buchanan's off on some cruise somewhere. Who knows what Brian Tully's doing with his life? He's a short, bald man. Sorry, you know, you shouldn't have messed with my mom. Now you all can get some. Anyway, so the gloves are off. So anyway, and then, you know, Michael Proctor, he's pining for the fjords, you know, in Norway somewhere. We traded him for Erling Haaland. You know, we took Erling Haaland in for the World Cup. We gave them Michael Proctor. As far as I can tell, based on my read of the documents, Michael Proctor is in Finland or Norway, wherever the hell they have fjords, pining for them. All right? He is also avoiding his deposition, and discovery closes in like a month. So anyway, things are just really weird, all right? In general, things are weird. We're going to talk. This order just came down, okay? And you want to know what's weirder? Why I'm so mad? Because American democracy does not mean I have to read a court order about motions that I can't read because they're not on the damn docket. Well, one of them I can read, ironically, because it's not on the docket. But Dee Dee's so quick draw, Super Dee Dee McGraw, that she posted it. Now, there's a lot to keep track of here. And you might be saying there's no way this is all in this order. Yes, it is. Yes, it is. And I'm mad, and I'm going to yell about it until the U.S. soccer game starts. So you got me for at least 2 hours, and I'm going to yell. Also, good job to Spain. Quite a goal. Quite a goal. Just snuck in. It was a very boring 80 minutes or so. And then the Spanish attacker just stuck in behind the Portuguese back line. Slotted it home. I think it was a left-footed shot into the back left corner of the goal. It was a good shot. Not as good as Erling Haaland's header or his shot from outside the box. Have you ever seen someone casually kick a soccer ball across the face of goal from like 30 yards away into the corner of the net, turn around, smirk, go to take his shirt off, and then be like, oh, I can't do that, I'll get a yellow card, and then just put his shirt back on? It was hilarious. Write that name down. Erling Haaland. You'll know it like 20 years from now. He's a legend. He plays in my club, too. I don't watch City that much anymore, but he's really good. He's just a tall Norwegian man. He's epic. Welcome, Erica S. Kwa. Enjoy your Super Towel emojis. All right, let's get reading. This is not going to take me 2 hours, but inevitably we're going to find something that makes me yell, so here we go. So here's what just came down. Now, I don't really know what this is as a court order. I don't really see that happening. Someone asked if there's a chance of Judge Gildea admitting a screw-up. Nope. We're going to talk more about what this is all about, but it's a bunch of orders in one, so we're going to read them. We're going to read it. All right. So this is what's called an acknowledgement, which I've never seen before, ever, of various motions to clarify the record. Now, I want to be clear. As far as I know, there are 2 of these 3 motions to clarify the record, or at least an emergency motion to clarify the record, and then a supplemental memorandum of law in support of the emergency motion to clarify the motion are not docketed. Nobody knows what they say. So for the first time that I'm aware, because I read a lot of court rulings, in the history of Massachusetts courts in the modern era, we are reading a ruling about a motion, 2 motions in fact, well 3. 2 of them are unavailable to anyone. I'm not talking, you can't go down the court, they're not on the docket, I'll show it to you. You just can't get them. No one can get them. It's created this weird world where I'm analyzing an order about a motion that I cannot read. Not because it's impounded. You're going to hear they should be on the docket. It's in the ruling. But they aren't. So I don't know what the hell this is about. And that's the problem. The hearing last Wednesday, if you don't know, I'm sure you probably have heard about it if you followed the Karen Reed and John O'Keefe civil case. Judge Gildea brought in 20 lawyers from around the country on 2 days' notice to lecture them about an ex post that we don't know exactly because of the timestamp, like a freak occurrence where both Aidan Carney, the journalist, who's actually a non-party witness in this civil case, and a party in another civil case in front of Judge Gildea, are deriving from the same action in the same court. We both happen to post things, although not at the same time, in a way that could constructively be read to have occurred at the same time because of the way Twitter timestamps work. All right, 2:52 p.m. Okay, this number is going to be bashed in my head forever. All right, you should have seen Oblivious Towel in that court. I didn't know about my post because all I did was repost a public court document. Anyway, there was a hearing last Wednesday about whether either a 10:52 a.m. ex post on June 6th that was actually rendered as 2:52 p.m. if you view Twitter while logged out. Okay, so it's possible it's this one about Michael Proctor and him going to Norway to pine for the fjords. Okay, he's clearly didn't say he was going to Norway to pine for the fjords, but we're going to talk about this in a roundabout way. All right, you understand? So anyway, then 4 hours later, whatever the hell it is, 10, 11, 12, 1, 2, yeah, 4 hours later, at 2:52 p.m. Eastern, Little Towel reposts a post from Kyle. His name's Kyle. He's Kyle. He posted a document at 2:46 p.m. that day, which was a document that was docketed at 2:22 p.m. Now that was a motion to impound a motion for a protective order for Michael Proctor to delay his deposition. Now Michael Proctor lost the protective order motion, but then won the impoundment order motion for like 30 years. Okay. That was docketed without a filed stamp, although it was appropriate to docket because motions to impound are public, okay? That part went up on the public docket. It's still there, but it went up at 2:22 without a filed stamp. Kyle downloaded it, uploaded it from Mass Courts, and then uploaded it to Twitter in screenshot form at 2:46 p.m. Eastern. He's that good. He just monitors Mass Courts. He lives inside Mass Courts. He's a little Mass Courts, like goat-based, shark-based gremlin. Anyway, so, and then at 2:52, because I'm a little towel, I reposted that document. I reposted Kyle's post, took the screenshots, re-uploaded them, and then summarized them. Okay? That was at 2:52. All right? So we don't know. Judge Gildea gets up on the bench, and he yells at the lawyers and tells them, this is relevant to this order, he tells them last week on the Wednesday, July 1st hearing in Plymouth Superior Court during a heat wave, it was scorching in that courtroom. All right, anyway, he tells the lawyers, listen, you got to go figure out what's going to happen if anyone else violates the protective orders in this case. Hello? No one had violated the protective order. There's no finding of fact. Well, there is a finding of fact that someone did. Judge Gildea wrote it in a written finding summoning the lawyers to court with 48 hours notice that there was a preponderance or something indicating, it seems like a setup, frankly, to me. Like, my alarm bells are flying off the handle right now. Because Judge Gildea puts in his written order compelling the parties to come to court, the lawyers, saying that there was evidence beyond a, whatever legal finding of fact wording he used to indicate that there was a violation of his protective order. Then, at the hearing on the 1st, all Judge Gildea did, I think we might be heading like on the train track to an appeal here. Now, it's an extraordinary circumstance. I'm not a lawyer. This is not legal advice, but I did go to law school. We may have a situation where a judge is trying to bootstrap in like a finding of fact of a violation of his order without allowing the parties to be heard. All he did at the oral hearing on July 1st was lecture the parties for 15 minutes. Alan Jackson, because he has to do this to preserve his objection on appeal, tries to be heard at the end of the hearing, and Judge Gildea's clerk tells him no. All right? So, I don't know, I'm telling you, I've never seen anything like it. I've read a lot of cases. I'd say like 25,000 at this point over my like time reading cases. I've read a lot of American cases. I've read international cases. I've read cases at the ICJ, at the ICC, at various regulatory tribunals. You'd be shocked what exists to resolve disputes in the international arena. It's fascinating. Anyway, I read stuff from all over the place. I've never seen anything like this in my life. Because listen, in every judicial proceeding, you need a record, okay? You need findings of fact. You need, like, the parties have to have due process. Even in the civil context, you need to give them an opportunity to be heard. Then you got to make a ruling. Then, like, although some rulings can and can't be appealed in the civil context on an interlocutory basis, you got to at least, like, do it. Here, I worry that Judge Gildea is up to something, because you're going to learn that what he said during the oral hearing last week was, I'm ordering you all to come up with an agreement that will result in things that could be from, dismissal of the case or a finding of default against Karen, which would proceed to just monetary judgment against her in the damages phase, which is what happened to Alex Jones. Okay? Although he deserved his fate. Seriously. I like Bill Cooper. I don't necessarily agree with all of his stances. Bill Cooper's the OG, okay? Alex Jones is a weak clone, all right? Put that in your pipe and smoke it. Plus, Alex Jones' dad works for, like, the defense intelligence apparatus down at University of Texas, Austin. But I ain't saying no more about nothing. I don't know nothing about nothing. I don't even know what the government is. So anyway, going back to all of this, I worry, I'm going to read this order. I worry, though, that the procedural history heading into this order is a harbinger of something very bad. I've seen what I thought were screw jobs. I'm serious. Not just at Survivor Series in 1997 either. The original idea of that screw job, which is actually a work double cross, work shoot double cross. It's very complicated. It actually came from the great, who was that woman who ran, she was at Killer Kowalski's school in Malden or something. Not Mae Young, Moolah, Moolah, she was not good. She got in trouble. But anyway, she was up against this woman in like 81. I want to say Wendy Richter. And Richter didn't want to drop the woman's title to her. So Vince was just like, screw her, just double cross her. And that's where they got the idea for Survivor Series in 97. But I've never seen like a setup double cross in the legal arena. It's always so much more like well-founded in law. Like you can't, like it's always airtight. This is, I don't know what the hell this is, but it feels like a bag job. A poorly done bag job. And I'm not trying to, well, I had my concerns when Judge Gildea watched Alan Jackson's interview ex parte on the Today Show, and then brought it up in a court order about, I want to say, like Colin Albert's deposition, just entirely unrelated to the matter at hand. He wrote it in the minute order too. So I think we might be heading to motion to recuse territory. I don't think he can do this case. Listen, I'm not a lawyer, okay? This is not legal advice, but I did go to law school. If I were litigating this, which I'm not, I would have immediately had, like, a serious team meeting over the ex parte, like, extrajudicial introduction of the Good Morning America interview into the Colin Albert order. By last week, I would have been like, all right, so we go to the Judicial Tenure Commission? Are we motioning to recuse? Are we going to the chief judge? Oh, I hope Judge Canody is not the chief judge in this district. Oh, she might be. She's the regional administrative justice over there, if I recall. I might be wrong about that. We should double check. What do you do procedurally? You could, I guess you could motion to recuse him, have him deny it, and then appeal it. But you're in this tough, because he's going to be the judge for all these cases. Listen, they got to get him off this case. Like, the trial court has to get him off this case. How has the trial court, as an administrative entity, not realize that this thing is heading for a massive problem? Hello, Towel Mum Buddy. Hello, Kofi. Hello, Bo. All right, so that's the procedural history. Let's go. The court has received Ms. Reed's emergency motion to clarify the record, submitted July 1st, 2026, and supplemental memorandum of law in support of emergency motion to clarify the record, submitted July 2nd, 2026, and motion to clarify the record, submitted June 12th, 2026. Backwards order. Paper number 127. Notice only one of them has a paper number. Now, listen to this next sentence very closely. The motions have been docketed, but no action is required on these filings as they are not the proper use of a motion to clarify. Pause. Pause. Everybody take a pause. We're going to look at the docket together as it stands right now, 5:51 p.m. on, what is it, Monday, July 6th, 2026. We are going to look at it together, and we're going to find out if Mass Courts wants to cooperate. And we're going to find out exactly what's going on. Mass Courts, seriously, what do we pay you for? You have been struggling today. You have really been struggling. Do you not have a big enough budget? Is it a problem with, like, your hosting provider? Is this like a Cloudflare issue? Like, what's going on here? Why can't I use my Mass Courts? You know what? I don't actually need it. You want to know why? Oh, here we go. It's fine. I want the actual record, but I do have a screenshot. All right, let's take a look. I got it. Now, the way you use Mass Courts is like this. Okay. I'm going to show you exactly how to do it. All right, so you go to the Superior Court, Plymouth County, Reed, Karen, all cases, search. It's going to bring you up the docket reports. We don't want the defamation case. Different case. We want ending 0692. We click. Oh, thank you for the flow state. I love a flow state. God bless you, Hills Bills. What a great username. So good to see you. This is the docket. Okay? Yay, we got the docket. Hashtag docket. This is what Kyle and Dee Dee do all day. You can't script it. You have to do it manually. You couldn't scrape this if you like depended on it. They hate scraping, which I don't understand. Like, bruh, you really want me to click manually? Okay. I hope you're paying for good server bandwidth, because I'm going to reload that damn thing every 10 seconds by hand. Sometimes I do it every 5 seconds. Sometimes every, 3 seconds. I'm a little compulsive. I'm quicker than a bot. What do you want me to do? Alright, so anyway, the next hearing is July 10th. That's Friday. That's on the motion to compel. Brian Albert, Nicole Albert, Matt McCabe, Jennifer McCabe, Colin Albert, Brian Higgins, Brian Thawley. He already lost, though, so he's getting deposed. That's supposed to be 2 days from now, July 8th. So he's getting deposed. And then, who else is there? Oh, Michael Proctor. So we'll find out how that's going. His deposition is delayed for the time being. And then there is July 16th at 9:45 a.m., which is conference to review status. Now, before we even get to July 10th, there's going to be you're going to find out that there's a deadline of July 9th imposed on the parties now, which, by the way, could really bind them in a non-appealable way. And then, frankly, I don't know what they're going to do here. So, look at this docket. Don't you love dockets? Hashtag docket towel. I'm a docket. You're a docket. This is a towel. I had a dental surgery today, alright? I'm up late. I'm going to watch the World Cup game in 2 hours. I'm going to order some dinner in an hour and a half. So let's do this. I never stay up this late. Why do you all stay up past 6 p.m.? Does anything good happen after 6 p.m.? I'm really not sure. The only time I'm up after 6 p.m. normally is if, like, bombs are dropping. So, I guess this is more pleasant than that. I always get very worried when that happens. Alright, so to begin, you heard Judge mention paper number 127. Alright, paper number 127 doesn't exist anymore. Okay? It doesn't exist. Now, Dee Dee saved it. Alright, we're going to talk about it. Thank you, Keith. Hello, so good to see so many of you. But look, it's gone. It's gone. It should be here. It goes from 126 to 128. Have been docketed, ladies and gentlemen. Did you read Judge Gildea's orders? The motions have been docketed. Okay. Where is my motion? How do I read the damn motion? I object. I object. Where is my motion? Now, Dee Dee posted it on June 12th. So, now, the only record of that motion is Dee Dee posting it. So, like, Dee Dee's better than mass courts. Hashtag Dee Dee's better than mass courts. And Cal. Cal was putting in work today. He was a Cal. Alright, now, what about this mysterious July 1st and 2nd motion? Well, pardon me. Now listen, I understand my eyes are getting up there, alright? I'm no longer a spry washcloth. I am indeed a towel. A big towel, perhaps. But even me, in my old age, my frail stage, well, I am pretty frail. But anyway, even this old aging towel can see that here we have July 1st. That was that hearing I just told you about. The very next filing, there's no filing on the docket July 2nd or July 3rd, which should be about this hearing. The very next motion is from, no motions on July 1st or July 2nd, as indicated in Judge Gildea's order from Karen's team. The very next thing is a motion, an order from Judge Gildea on Brian Tully's attempt to avoid his subpoena that Tully lost. And then what do we got here? Another order, same thing, on Tully's motion. Because this is the endorsement on the motion and this is the full order, okay? Order on the Turtle Boy subpoena, okay? Order on, yep, and so there's the endorsement on the motion, there's the order. And then this today that I just read to you. Where are these motions? Is this not an order from a Superior Court judge speaking in the past tense, saying that these motions, all three, it's unambiguous language, have been docketed? Where are they? And why was 127 taken down when it was already up? You want to know how I know it was already up? Because I'm a towel. Look at it. Look at it. That's paper number 127. Dee Dee pulled it from mass courts on June 12th. Look, I have her post from June 12th. So tell me, ladies and gentlemen, what has happened here? I feel like Jolene. I'm very baffled. Where are these motions? They're ghost motions. It's like that episode of Hey Arnold about the ghost train. Where are these motions? Where are they? I can't find them. How I can't understand what Judge just said. First of all, it would be one thing if he said these motions are not to be docketed, because then I could be like, well, that explains why I can't read them. But the order says they're to be docketed, so where the hell are they? And by the way, the mass courts issue only affects the loading of what's called images, which are just the PDFs, okay, for civil cases. You can look at them. Okay? The public, you can just look at it. It only affects that. It doesn't affect actually docketing things. So where are these documents? Hello, Bailey Love. Hello, Scott. Hello, Madeline. T.A. Sarah. 77 billion bonus points for T.A. Sarah being a good detective. She's a T.A. and a detective. She's going to be in charge of your final. Listen. Normally, if I was mad about something morally, I would tell you. I'm not mad morally. I'm mad procedurally. This is like, it's a teaching moment. This is like the difference between procedural and substantive due process. Okay? Procedural due process, for example, is what things you're entitled to during a hearing. It's that famous case, I want to say it's, oh God. It's the very famous case about benefits. Dylan? It's a long time ago. It was in the 40s. But yeah, procedural due process is like how many rights do you get at like a hearing for like an administrative body. Okay, that's procedural. There's procedural due process in the context of Article 3 courts too, civil and criminal. But that's procedural due process. The form, the rights that you get, etc. Substantive due process is the merits. Okay? You have both rights. You have rights to procedural fairness and substantive fairness. Okay, everyone understand? I've never been procedurally mad. Do you know how rare it is for there to be a procedural due process issue? It's incredibly rare. I've never heard of it coming up in this context. Denying someone procedural due process rights, it's like a cornerstone to avoid appeals. The judge has to meet that bare threshold. Where are these motions? Why weren't they given time to be heard? I mean, that it's not even reversible error. I don't know. It's not like relevant to the case. It's more relevant to the judge's capacity to act as the gatekeeper, like as the arbiter. It's a very serious situation. I have very serious concerns about the integrity of this docket right now. At least right now. Maybe tomorrow listen, with this case, who the hell knows? Maybe it gets updated tomorrow. But as of right now, based on that court order and this docket, I have serious concerns about who's managing this docket, who's overseeing this. Is anyone even paying attention to this from the trial court? Does anybody care? I'm a little bit worried. We have my red flag meter. Listen, you can watch my streams over the past 3 weeks about this. When Judge Gildea watched that ex parte television show and brought it up in an order, I didn't lose it. I wasn't telling you to sound the alarms and say the British are coming. I was saying we're at a low frame drop. If those motions never flow state, I love flow state. Thank you so much for that. Our NK Kitty motion. We can't even get to, we have to stop our analysis, and I'm going to talk about this a little more. This can't happen. Okay? It has to be rectified tomorrow. And you got to understand how these lawyers for Karen must be feeling. Because they're like, what are we going to do here? He's not even docketing our motions. Like, what are we supposed to do? We're just going to make them more mad. They got to get out of that court. Or they got to pick a handle. So good to see you. They got to get out of that court. Something is terribly, terribly wrong. Just that first paragraph is so wrong. It doesn't make sense. It's not accurate. And it's depriving the public the right to know what Karen said in her motions. Her lawyers must be very concerned. What is this? What is this? I don't even know who you go to. I'm being very serious. I don't know who you go to about something like this. I guess the governor's council at least has an advisory role for the appointment, but this was under Baker. So who intervenes here? The parties. This is more about like the integrity and the accessibility and the transparency of the courts than about Karen Reed. Karen's very central to this, but like it doesn't really fall on her shoulders. Like she's in some sense in a very precarious position. And the weird thing is, like, is somebody telling this judge that like Karen and Turtle Boy are like Alex Jones or something, and he should just like he doesn't have to give him the time of day? Like, did you listen to Alex Jones's lawyer arguing down in Texas and in Connecticut? Oh my god. I'm pretty sure if Alan Jackson met that man, he might, as a colleague, like shake his hand, but I think Alan would be like, I can't spend time around these men, I'm gonna lose intelligence. Alright, so it's not the same. Like, what are you doing? There's at least, I'd say, 250,000 eyes on this docket on a daily basis. I'm not over-exaggerating, Judge. I'm trying to be respectful. I don't even know who to, like, redress my grievances to about this. We just have to stop. And I need to just say this again. I need to reinforce how abnormal this is. Because if you normalize the absurd, then nobody will care. You have to stop and actually point it out. So I need to tell you, as someone who has read 25,000 court decisions, as someone who has gone to law school, but... Are we back? No, we're still frame dropping a little bit. Give me 1 second. We're back. As someone who has read 25,000 cases, as someone who has gone through law school, although is not a lawyer, I have never in my life read an order where I could not at a basic level interpret what the judge is saying because the documents are not on the docket. In a situation where it's very high stakes, remove me or Aidan Carney or anyone else from this. The public's right to know. Listen, you read New York Times v. U.S., okay, from 72, the Pentagon Papers case. One of the core oral arguments is that the public's right to know in a democracy is the only safeguard against the usurpation of our institutions by ungodly conflagrations. Nothing can really be ungodly, but like unholy conflagrations or usurpation. You know what I'm saying? Both of those are bad. And I can't tell you what judge is even saying because his ruling doesn't reflect the docket, and those motions, which should have been docketed on July 1st and 2nd, respectively, were never made public by the clerk due to some extraordinary act of God that I can't explain. I live in a democratic republic, and silent dogs, you'll have to rip it from my hands. We were passed it down, and by God, I'm going to protect it. Now listen. Everybody pause. Okay? Because there is a June 12th motion to clarify the record that we can look at. Okay? How do I know? This is paper number 127. Okay? And it says, it's a motion to clarify the record from Karen. And it says on June 8th, so this is going all the way back to the hearing, the 2 days of hearings, where Michael Proctor tried to delay his deposition and lost. Okay? On June 8th, the court heard arguments concerning Michael Proctor's emergency motion for protective order. During the morning portion of the hearing, this is Karen's lawyer's writing. The court stated that it was unreasonable for Karen Reed's legal team not to have provided notice to Mr. Proctor's counsel that Reed planned to file a separate lawsuit in Bristol Superior Court against the MSP in town of Canton through its police department days before his scheduled deposition on June 8th. The court also cited comment 4 to Rule 3.5 of the Massachusetts Rules of Professional Conduct in connection with this filing, suggesting that this alleged failure to provide notice was somehow improper. The court also referenced the fact that Ms. Reed and her counsel appeared on television on Friday, June 5th, because none of these facts or arguments... Oh, hold on, I might have posted it out of order. Does it just end June 5th? Oh, it's just a period. Right, that was that extrajudicial notice of that TV appearance, but it just ends with a period. Because none of these facts or arguments had been raised or addressed by any of the parties prior to the court's statements. That's true. I think Judge Gildea read this in the defamation case. I think somebody supplemented a pleading like 2 days before Judge Gildea issued that weird order about the Good Morning America appearance, and I think that was in the supplemented pleading in the other case. I'm serious. I read it. I read everything. You know what? I don't know who I have to talk to. I might have to go... Damn it. I might have to actually go talk to the government. Damn it! This is really bad. This is bad in a way that Alan Jackson can't resolve. Because he'll just get it taken out on him. Oh, this is bad. I gotta figure out who I'm gonna talk to. Where do I even go to redress this grievance? I guess I have an idea. I'm gonna make some calls tomorrow. I need to talk to a few people in places. And I just need to figure out what they think about this. And then I can determine what I should do. Yeah, there's a few people I need to talk to. I couldn't do it today. I had a dental surgery. And this order didn't come out till like 4 o'clock. I was like trying to get home. I was all confused. The Uber was driving me home. I had dental surgery. I was all mad. They stuck a needle in me. You can't just stick a needle in towel. You got to give me some heads up about these things. So anyway, my point is, something's very wrong. I'm a very, just like, I can't put my finger on it, and I hate this. I hate this for this case. This case, listen, it's so unfortunate that this has happened. You must understand. This was never just going to go away. Never. Ever. Like all it needed, like we were almost there. You just needed like a Watergate style modified limited hangout. Like people just needed to be like held accountable, and you didn't need to ask too many questions. You just needed to pick a fall group and let them be held accountable, and then the public, much like Watergate, no one's gonna look at the Chilean fucking embassy burglary, sorry to cuss, if you give them Nixon. Jesus. This state infuriates me because I can't put my finger on it, but I think something very bad is happening. And all this case needed was an impartial jurist to just take it through. That's all it needed. I can't believe this. I didn't have this level of concern until today. And maybe it'll be tempered down a little bit if we see these motions go up on the docket. Okay, it will. But it doesn't remove, it will go from like an 8 to a 7. Okay, because if they never go up on the docket, we're at like you gotta break glass moment rhetorically. You have to. It could, like, if you let this slide, this is gonna go very badly in the worst way possible. And civil cases are very different than criminal cases. There's no deprivation of a liberty interest at stake. You cannot appeal pre-trial rulings for the most part. There's no interlocutory right to appeal. You have some interlocutory rights to appeal under 211.3 and 118. I want to say, I don't remember the subsection. You have interlocutory appellate rights, especially in criminal cases, but you don't have them for pretrial orders in civil cases unless it's a finding of criminal contempt. So, what does that mean? To appeal an order compelling you to appear for a civil deposition. This is an example. You have to get held in contempt. You have to not appear, get held in contempt, like get jailed or fined, and then appeal the contempt order. You have no right to appeal the order to show up at the deposition. You don't. I already looked it up. Hi, Marcia. Good to see you, my dear friend. You're wonderful. Hello, Pat Ray. How are you? So, listen to me. I don't mean to do this without cause. There is very good cause to be paying very close attention to everything that happens between now and July 9th for a number of reasons. Because this is one of those moments, it's an inflection point, quite literally. This case is going to go down one of two paths. It's going to be completely controlled by a jurist who, being very favorable to Justice Gildea of the Superior Court in Plymouth, is inadvertently consuming extrajudicial information and then basing rulings on it, okay, and then doing it again, and then not allowing the parties to make a record, and then bootstrapping in a finding of fact to an order compelling attorneys to show up to court for a hearing at which they couldn't talk, and then at that hearing and in a follow-up order compelling them to sign an agreement saying that further violations... I caught that frame drop. Come on now, come back. There we go. I caught that frame drop as it happened. It's not, by the way, I have very good internet, but I use a special software to stream. It cuts off the middleman of like third-party softwares. I literally take my computer and take the frames and send them to the server. The server has to accept them. They're great servers, but like when you do it manually, you're literally, there's no intermediary. You're doing it yourself. So it's like 99.8% up, all right? But yeah, that's why it happens. And I like it this way. I don't like those middle clients that do streaming services because they're running through a like separate hosting environment, and if that goes down, like I don't need to think about whether AWS is going to go down in the eastern region and impact my ability to stream. I want to be feeding it directly into the server through an RTMP client, and that's what I do. But it comes with a cost. All right, let's continue. So, back to what I was yelling about. All right. There's something wrong here. Even in the reading this in the light most favorable to Judge Gildea, he's made some terrible mistakes. Mistakes that you can't make even as a first year like prosecutor or line attorney. Okay, you just can't. As a judge, it's way beyond the pale. Just some of the mistakes. Not to mention what's transpired over the past week and with this ruling. In the light most unfavorable to Judge Gildea, he mistakenly, going all the way back to the TV appearance Alan Jackson and Karen Reed did, mistakenly thought the supplemental pleading in the defamation case was the record before him in the wrongful death action, and then made a finding of fact in an order on the basis of that information that was not before him, which I think is likely. Because the other option is he just watched TV and was like, who cares if anybody brings it to my attention? I watched, I was watching the Portugal game. Somebody held up a sign that said, I love Karen Reed. I'm going to bring that into the record. Why not? Why the hell not? It's a free-for-all these days, apparently. He's going to write an order that was like, well, somebody was commenting on the World Cup in the broadcast that went to the Czech Republic. And I translated it from Czech, I think that's the language they speak there, to English. And, you know, it sounds like the man was saying Alan Jackson was talking about the Karen Reed case. Violation of the order. Listen, I don't mean to take this to extremes, but how do you want me to process this? It's the collapse of my damn democracy. Not about this case. About any other case. Why can't it be about a mundane thing? It could be about any other case. Why this case? Not this case. Not this place. Not this time. It can't happen. By the way, continuing in the light most unfavorable to Judge Gildea. Then, Judge Gildea issues his odd order compelling everyone, all the lawyers in the case, to come across the country, in some cases on 2 days' notice, about an ex post, right after Karen's lawyers raised concerns about in the Brian Tully response to the Brian Tully motion to quash. Karen's lawyers inadvertently misled the House, as they'd say in Parliament, said that the court was giving the witnesses in the case special treatment. How much you want to bet that sanction that wasn't a sanction, flying all the way across the country, was as a result of the comments in the motion to oppose Tully's motion to quash? 100%. Which is incredibly inappropriate. That's my opinion. Furthermore, okay, that's 2 strikes, at least, okay? Where we're at right now, barring some extraordinary development, this first paragraph, we haven't even got to the second paragraph, which, by the way, I'm going to analyze, is strike 3. Unless there is a drastic change of events by tomorrow afternoon, July 7th, and these motions appear, something is very wrong. Fool me once, shame on you. Fool me twice, shame on me. Fool me 3 times, I'm petitioning the government for redress of my grievances. Alright? So anyway, that's just the first paragraph of that. You must understand, all these motions should be on the docket. The one from Karen, docket number 127, okay? The one I just explained to you about, and this is about Judge Gildea's comments, okay, at the hearing on June 8th. This should be on the docket. This is a mystery document. Look, it should be 127. 124, well, this is a 9A package, so it's 124.12345, okay? 126. 128. It's gone. It's gone. And, again, to reiterate, this motion, right, emergency motion to clarify the record, submitted July 1st, 2026. And this motion, Karen's supplemental memorandum of law in support of emergency motion to clarify the record, submitted July 12th. Those do not exist on the docket. Now, maybe you might say, well, okay, judge just didn't accept the pleadings, whatever, so they were never put up there. No, those documents are from last week, and judge in the very next sentence says the motions have been docketed. No, they haven't. No, they haven't. This is, I got to remember the Tao of Heavenly Sea and the sea creatures, okay? We're just living in a parallel universe, okay? It's just a parallel universe when you talk about this case, and people just do whatever they want. Nothing matters, and you can just make the rules up as you go, and you make timelines up, and you make stories up, and you put Chloe in the Doggy Witzak program. All right? You just make it up as you go. That's why Habermas's critique of legal rationality is so apropos. I've never been so frustrated with a paragraph in a judicial order in my life. And I've read Clarence Thomas's dissents. I've read Justice Black's dissents about the 14th Amendment. God help his soul, they make more sense in this paragraph. That man hated the 14th Amendment. I'll tell you. Oh, God. I don't know if that whole renouncing the Klan thing was actually true, because that man hated the 14th Amendment with every fiber of his being. Now, it worked in my favor on the corporate personhood thing. He wrote a really good dissent in Connecticut General Life Insurance v. Johnson from 1939. You gotta read Justice Black's dissent. Oh, that's one of my favorite dissents. Okay? But then you get up to, like, Loving. He gets a, oh, it's not good. He's kind of a bigot. And, you know, he might have eventually come around. But, yeah, he hates the 14th Amendment. He just hates it. I've never seen anyone hate anything as much as Justice Hugo Black hates the 14th Amendment. The man, I'm pretty sure if it was up to him, he would just erase it from the Constitution. He hated that damn thing. He was willing to apply it very narrowly. Very narrowly. Oh, God. But anyway, my point is, I've read some tormented judicial reasoning, but what makes it so frustrating when you're reading tormented judicial reasoning is you're like, well, damn it. Like, their clerk and they, like, knew it so damn well that they got me. Like, I can't argue against them. Like, I loathe their conclusion, but they found, like, this, like, 1847 case that's never been overturned and is good law. It's green on Westlaw, or Lexus or whatever, that's never been questioned, that's good law and controlling precedent to this circumstance on these facts. That's what's normally frustrating about a tormented judicial decision. This is the first time I've ever seen a paragraph that is factually, by a judge, that is factually inaccurate to the docket as of now. I'm putting a caveat on that who knows, tomorrow maybe that'll change, okay? And that contradicts itself. That orders motions to be docketed and refers to them, but then all of them are not docketed. Sarah B. Creative says, so much love to you, my friend. Thank you so much for becoming a Talent member for 5 months. You're wonderful. I've never seen it. You just can't. Does he have a clerk? Did somebody read this? I'm not being overly judgmental, by the way. Every person who reads this, whether it's Attorney Melanie Little, who's wonderful, shout out Attorney Melanie Little, we'll watch video after this document. I think Brother Counsel will probably, I can't speak for them, but I think Brother Counsel is probably going to be shocked by this. And you got to understand, I value all of your opinions very much, but I can't gut check myself. Like, I need to listen to the people who analyze all the documents, talk about it. I don't think they're going to have a reaction that's anything, like, it's beyond quizzical, it's beyond quixotic, it's actually, like, concerning. I have serious and grave concerns. But you gotta watch all of us read it. If we all have the same reaction, that should tell you something. Something is deeply wrong. I can only imagine. I can, well, here's the problem. Norfolk Tyranny says, Brother Counsel said Karen should file a motion. I know. And so did the wonderful and venerated Corey A. Hopkins, Marbury v. Madison. Marbury v. Very Madison. Great pun, by the way, on Twitter. You know, listen to me. What we're up against, and I mean this directly, is they're not docketing Karen's motions. It says they should be docketed. Where are they? Do we need us? Alan can't even make a statement. Listen, this is the worst possible situation. This is very... Barring extraordinary intervention, this case could go down a dark path. For Karen. You gotta sound... This is not Judge Cannoni. This is not someone sending a Facebook message saying that Judge Cannoni is their aunt, etc., and that Judge Cannoni and them, or that they're going to bury the person under somebody's seaside cottage. I don't know what the hell that was all about. It was bait. Anyway, with that, okay, the purview of judicial discretion on recusals, you're not even close. You are not even close. Sorry, she didn't say it. Some dude could just be trying to flex, and make stuff up. She has no, it doesn't meet the standard. Here, if these never go on the docket, forget motion to recuse. I don't know if this docket's even being managed appropriately. And that can't be a question. You must understand. Like, we're supposed to talk about the substantive legal arguments. Maybe some procedure, like somebody brought up like that their rights were deprived because like they were doing something and somebody else did something, and then there was a deprivation of a right, and you're raising a procedural objection or like a procedural due process argument. We should be, and even that's substantive, although it's a misnomer to call it procedural, because there's substance to procedural due process violations. It's just different than substantive due process. The point is, that's what we're supposed to analyze. Like, we're supposed to be able to tell you, like, this is what they're arguing. Either the other side objects or doesn't. And if they do, here's how they object. Here's the response from the moving party, the movement. Okay, nice tight little package. Here is what judge considered at oral arguments. Here's the questions judge had. Maybe a ruling from the bench. Maybe a ruling in a judicial order. Not this. What is this? You can't just strip her of her right to docket the motion while simultaneously declaring the motions are docketed. And I know some people are saying, rightfully so, there's a mass courts issue. Yes, but it only has to do with the loading of images. Docket entries are still going up. I checked a bunch of cases. Docket entries are going up. It's just the PDF files from the image link are not loading. And I think the reason why, and I will read this next paragraph, but I know it's going to require a lot of analysis. The reason why I'm waving a red flag here is this doesn't feel like a judge is wrong. It doesn't feel like a judge is embarrassed and trying to protect himself. It feels like the fix is in. And I should not be saying that. Listen, you have watched me, if you watch these streams, for months, cover bombs dropping on people. Right? And although it got very intense, I could still call it down the middle. I'm calling this down the middle. Oh, God bless you, Sarah. Be creative. Hello, Clumsy Clairvoyant. So good to see you. Hello, Hamnasis. And hello, Pat Ray. And Bunny Towel and Kofi. I wish I could get over this feeling. I wish it was more like, oh, Judge is just, I get where he gets this from, but like, he's just wrong. Like, I get the case law gives him the footing, but like, if he just would consider like this, he'd see that he's applying it wrong. Nope. Nope. So what is he doing and why? I want to do an analysis. Why would he do this? I don't know him from Adam. He was a town council in Brockton. Then Charlie Baker nominated him in 2017 to be a Superior Court Justice. And his hearing was a little contentious. He mostly does municipal stuff. I would guess like permitting ordinances, zoning variances, challenges to those various things, etc., etc. municipal law, as it would be called, but it's more like property law. Like most municipal law is like zoning and permitting. I don't want to get into it. I guess I should, to explain what he would have been doing. So his job kind of would have been, like, say the town was looking at what zones in its borders were defined as, like, mixed use versus, like, single use versus, like, business use. And they wanted to create, like, a special permitting zone for, like, a type of business that was being created that didn't exist before. Or, like, they wanted to expand the number of licenses for, like, a specific type of business, so they needed to change the number of areas, because, like, certain businesses can't be within 500 feet of other businesses, or a school, or a church, or a playground, or what the hell. That's what they have to think about. And then they have to think, like, is the rule that we're writing permissible under the statute? Like, does the enabling statute allow us to write a local ordinance that is in compliance, that does what we want to do? And then normally, like, the Board of Selectmen, the town council, whatever, town meeting, will vote on whatever issue it is, and then it will go up the local legislative chain, and then, like, it'll either get challenged or it'll be passed. If it gets challenged, the town council advises the city council, the mayor, however they run the Board of Selectmen, on how to deal with the lawsuit. The town council represents the town in any lawsuits, especially related to that. You can have things like civil rights violations, malfeasance in office, those type of things where it, like, is sued, the town sued, and the town council represents them. But a lot of times that's like the attorney general, depending on, or like a private counsel. It depends on which capacity the person's acting in when they get sued, whether the town sued as an entity, etc. The town might get outside counsel. Some towns don't even have a full-time town council, so their town council is just some guy with a law office that they hire to do town stuff. If you can't tell, I do a lot of municipal oversight in the Commonwealth, so I know a lot about this. Now, I get that it may seem, or maybe there's like a bias that will come about from watching this stream. You may think, well, listen, Grant just knows all of this down pat, like municipal law, civil law, criminal law, Supreme Court precedent, constitutional law, history, philosophy, what media, whatever you want to talk about, the war, like, he knows. So therefore, our judges should know the same. I'm not tooting my own horn, but I just gotta manage expectations. Like, that's not how it works. Lawyers normally practice one thing their entire career. That's why I'm not gonna be a lawyer. That's not what I do. You can't, and we shouldn't, expect lawyers to be polymaths. They specialize in, like, one field of law. That's what they do. Like housing law, family law, criminal law, constitutional law, except civil law, etc., etc. Wills, trusts, and estates, malpractice, med-mal, etc., etc. They need to know it. Like, they need to know one thing really, really, really well and do it all the time. I don't understand. I know Judge Gildea has been trying cases since 2017, 9 years. I don't understand what is going on here. I really don't. Because I just can't get over the fact that there is no access to these documents, and there's also no substantive, procedural, or otherwise legitimacy to any of these rulings. They're just words that a judge who I can't understand is putting on paper for reasons that aren't fully clear to me. It's very frustrating. Alright, so here's what Judge goes on to say. So again, this paragraph is not accurate. As of right now, it's just not accurate. I'm sorry, we can't read these motions and they're not docketed. So, I'm having like an existential crisis because the judicial system is not working. Not it's wrong, not that it made a decision I don't like, it's just not working. It's broken. This case has broken the judicial system. Judge Gildea worked himself into a shoot. He either thought about this too much, somebody's pressuring him, he's hiding something, or he was told this is going to go a certain way, make it happen. And he's trying to make it happen. Do you remember the episode of South Park where Randy gambles away the family's house at the tribal casino? And then Randy returns to his family and he asks Stan if Stan doesn't like South Park anymore. And Stan's like, yeah, kind of. And Randy's like, oh, so you want us, what you're saying is you want me to sell the house and you just want us to leave. When he had already lost the house gambling. Now, I'm not saying that anybody was gambling here, but by analogy, see where I'm going with this? Like, Karen's sitting there like, but I didn't say we should, I don't mean to do this to Karen, I hope she gets another house sometime, but she's making her stand in this situation. I didn't say we should sell the house. That's why it feels so odd. Because there's something, like we know something's wrong. We know Judge Gildea's not doing this because he's trying to send Alan Jackson a message. Come on. He could do it lots of other ways. We know he's not doing this because Karen's lawyers wrote, although it was definitely partially this. Karen's lawyers wrote in the Tully opposition to the motion to quash that the certain trial witnesses were getting favorable treatment from the court. No. Nope. There's something deeper here. I don't know why. And that's, like this case, it's been 3.5 years. We just figured out the Mystery Man, the Sally Port footage, the timestamps. That took 3 years. We can't do this again. Like that, literally, listen, that case tore, you don't understand, it tore families apart. It really did. It had lasting fallout. We can't, I'm so mad at these people. You know what I'm holding out hope on, although I think it's only 5%? That this is like that massive corruption bust in '84 in Cook County, Illinois, or whatever it was. I forget what Operation Fort something, I don't remember what it was called. Where some of the judges and lawyers pretended to be corrupt to get dirt on the corrupt people. I'm giving that 3%, but that would redeem my faith in the justice system. Because otherwise, no. Unless these motions go up on the docket, I have to say I think something has gone terribly astray. Alright, so anyway, after judge says the motions have been docketed, but no action is required on these filings as they are not the proper use of a motion to clarify, all judge is saying is they've been docketed, they're on the public docket, but they're motions to clarify and they're not the proper form, so I'm not going to take action. Now, when you don't take action on a motion, you leave it on the docket. Okay, that's all judge is saying. He's saying they should be on the docket, including the July 1st and 2nd one, but I'm not going to take action. We still should be able to read them. The second one, second paragraph. Such a motion, referring to motions to clarify the record, should be a targeted request to the court to provide clarification of a previous judgment, order, or ruling that appears unclear. It should not be used as an opportunity to respond to generic statements from the bench, submit additional information, or to seek to get a party's position into the record. Footnote 4. Footnote 4 says, it's not a case citation, it cites to paper number 127. Paper number 127 acknowledges that its purpose is to address and respond to the court's statements. Any similar motions sought to be filed in the future will not be docketed in the future. And also, is that actually what Karen said in her motion? Let's see. Pointed out a mistake by Judge Gildea that he took into consideration extrajudicial information. Alright. Oh, in a footnote, to address and respond to the court statements without the need for a formal motion, Reed's counsel sent a letter to the court on June 8th addressing these topics and simultaneously e-filed that letter with the clerk's office. However, the letter was eventually rejected for filing. Oh, wow. Wait a minute. So they tried to bring it up via letter, as we know. Then the court rejected it. Then they bring it up via motion to clarify, and the court rejects that? Hello, Interpretowel. I'm so sorry that Kofi ate your notes. Are you kidding me? So they can't do it by letter. They can't do it by motion to clarify the record. If counsel wishes to bring to the court's attention information discovered after counsel's June 26, 2026 letter to me, a motion for reconsideration in compliance with Superior Rule 9D, Superior Court Rule 9D, is this a typo? Would be proper procedure. 6. Okay, hold on. Okay. Okay, pause. What is this letter? What is footnote 5? Such letter and the June 25th letter from counsel for the non-party are provisionally impounded pending any further hearing on the issues raised therein. What letter? What June 25th letter? What letter? I don't see any letters. I don't understand. Dude, why are you there? Why can't you put it on the docket? Are you telling me that people are sending letters in and they're not being docketed? That's it. I'm going to call the Globe. Don't make me call the Boston Globe. Listen. I'm going to do it. I'm going to call the other papers. I'm going to call the Pool. You're denying our right to access to the public docket. You can put the document up there without, and then under impoundment, and you just put letter to court. Listen, that's it. I'm mad. There's at least 4 filings, 2 letters to the judge, and 2 motions from Karen that are just not on the docket. They weren't rejected for filing. They're just not on the docket. We just can't see them. 2 of them are impounded, but we can't even see the docket entry noting that they're there and then saying they're impounded like every other case. And then Karen's motions from July 1st and 2nd just aren't on the docket at all. Oh my. This gets worse the more you read it. When you initially read it, your brain, especially if you know the case and understand civil procedure, your brain just goes, what? But then when you actually review it and tear it apart, first of all, there's a typo. Second of all, it's even worse than it looks. It's even more terrifying. And I don't know how to process this. I don't know what words to use to describe what is happening to my docket, to my court system, to my democracy. I don't know what to say about this. A motion for reconsideration in compliance with Superior Rule 9D would be proper procedure. So let's go to footnote 6. Rule 9D provides that such motions shall be served and processed consistent with Rules 9A and 9C. So you got to do a 9A package. If a motion under Rule 9D is filed, oh, and then a Rule 9C is like a conferral. Rule 9C conferral would necessarily include the non-party's counsel. I recognize that conferral with the other parties in the case may not be warranted and accepts such requirement at the option of Ms. Reed's counsel. So they have to comply with 9A but not 9C, and they also have to comply with 9D. Even though I do not consider the issue to be an emergency, I would, as always, accommodate counsel and schedule an expedited hearing on a mutually agreed upon date. What he's saying? First of all, he's saying you don't get an emergency hearing. She styled it as an emergency, Karen, and he's saying you don't get that. Second, he's saying if you're going to do a motion for reconsideration, it's got to comply with Rule 9A, which is, do you understand what that means? Let me explain it to you. He's saying, and we'll look at the rules, you got to write the motion, serve it on the other counsel before you docket it, wait for them to write a reply within 10 days, then you can write a reply yourself, then you have to compile all the documents and a cover letter and send it to the clerk, at which time they'll all get docketed together. He wants them to wait 15 days at minimum to do a motion for reconsideration. But that's not relevant to our question about where the July 1st and 2nd letters are. He said they're going to be docketed. This is a whole different question about what they should do in the future. Then, Judge Gildea says, with respect to the submissions of July 1st and 2nd, the only relevant order of the court was to preclude further attempts to take discovery from a non-party, Michael Proctor, pending further orders of the court. The court invited counsel to come to an agreement to hold private personal information in confidence, which the court would consider entering as an order. If no such agreement is filed before 4:30 p.m. on July 9th, 2026, the court will issue further orders it deems appropriate. So he wants them to agree to bind themselves in the form of a proposed order, a joint proposed order, essentially waiving their objections on the basis that private personal information was already spread when it wasn't, and on the basis of an evidentiary record about a tweet that, although Judge Gildea mentioned by time, has never been seen by anyone. He wants them to bind themselves to an agreement, in essence incorporating by reference. I know how promissory estoppel works. He wants to incorporate by reference his prior actions, which Karen is trying to challenge as illegitimate, and then he's saying if you want to do a motion for reconsideration, you have to do the 9A process, which is going to take you 15 days. And by the way, on July 9th, I'm going to rule if you don't get me a proposed order, regardless of whether you submit a motion for reconsideration, which you can't possibly get before the court before July 9th, I'm just going to rule. Dude, what? What? Listen, I know the rules of civil procedure. This is tomfoolery. I see what he's doing to them. I wonder how many items are flying around the Workman Jackson Quinn office this afternoon. I wonder if any of the chairs are still on the floor. It's not facially egregious, it's legalese, so you don't read it like the Proctor messages and just get mad. If you know the law, I'm not a lawyer, I did go to law school though, this is not legal advice. If you know the law, not to mention if you're a lawyer in this case, oh, this is infuriating. Because it's not a positive for any side in this case. It's just more negative for Karen than for the other parties. You must understand. it's not like these are rulings that are going against Karen on the merits. They're, to speak candidly, bordering on rulings with, and I say this only because it's the record before me, with no factual record and no opportunity to be heard. And in fact, very kind of convoluted procedure being used to deny them an opportunity to be heard. Karen's legal team. Worst case scenario for Karen, but not a good scenario for anyone involved. Because with a ruling that is bad for one side but sound, people debate it, you talk about it, etc. With a ruling that, first of all, is non-transparent, and second of all, when you actually look at what the court's either forcing Karen and her lawyers to do by July 9th with the other sides and other parties, or going to do on the court's own, in the context of basically not hearing the motion for a reconsideration that Karen filed on July 1st and the follow-up supplemental memorandum on July 2nd, and then saying, oh yeah, I'll think about a reconsideration, but you got to follow 9A, which it doesn't spell it out here, but do you know what 9A means? A 9A package. You must send it to the other side, wait the certain number of days, and therein is the trick here. He sandbagged her. And as a lawyer, her lawyers, they must be furious. Now listen, you don't get emotional. It's not my job. Those lawyers get paid hundreds of dollars an hour. You don't get $450 or more. That's the low end. You don't get emotional. You know what you do? You breathe. We have a constitution. We have laws. We have precedent. And you find a reason or a way to get out of that court, even if on a narrow issue, and have some kind of appellate review. It's almost like when Judge Glanville in the YSL trial took little Woody into the back. I'm serious. It's almost that bad. Into the back room, into chambers, ex parte with the prosecutor, and leaned on him to try to force him to testify against, oh God, I don't remember. There was like 40 defendants in that case. But anyway, Judge Glanville got removed, but you are damn sure he tried to throw one of the attorneys in jail. He did jail one of the defense attorneys. The defense attorney was like, Judge, I remember this now. That guy was good. I forget his name. He was like, Judge, if you're going to jail me, I demand you put me in the same cell as my client so I can work on his case with him. Otherwise, you're depriving him of his Sixth Amendment right to counsel and our ability to conduct this case expeditiously. It was one of the greatest moments I've ever seen in a courtroom. I used to watch that trial live. Judge Glanville was a jerk. The point is, I could tell that it was a bag job when he did that. I forget what happened with the prosecutor on that case. God only knows. That case is very strange. But there was some tomfoolery down there. And he got in a lot of trouble and removed from the case. Brian Steele. Yeah, listen. You find yourself in a position where you need Brian Steele and can afford him. Get Brian Steele. I mean, that man, Alan Jackson is really, really good. Oh, thank you for the Flow State DD Teams. You're so wonderful. Alan Jackson is great, but I've never seen anyone do that. Like, as far as I know, Alan's never threatened to get, like, arrested in the middle of a courtroom. Maybe he has. I haven't watched all his trials. Brian Steele, no pun intended, nerves of steel. We're talking a little bit about the untenable position that Karen's attorneys find themselves in, because by analogy, I'm not saying Judge Gildea has brought a witness into chambers with one of the parties and leaned on the witness, because that was just extraordinary and very bad. But we're nearing, that level of concern. We got 4 examples now of motions that just didn't go on the docket, whether denoted as impounded or otherwise. And then 2 of those motions, which are very important because they have to do with last Wednesday's hearing, and they have to do with whether Judge Gildea read a Twitter post, either ex parte or otherwise, and then misunderstood it or didn't know the timestamp or didn't do an investigation, scolded the lawyers, found a finding of fact that they violated a protective order. Nobody knows why or what the post was even about because he didn't specify, the judge. Then, more importantly, this order, the biggest thing to take away from this order, is Karen doesn't have enough time to file a motion for reconsideration of an order that is forcing her by July 9th at 4:30 p.m. Eastern to enter into an agreement that will basically bind her by reference to Judge Gildea's previous order, which had no finding of fact or explanation for anyone, binding her to that, and then saying that there will be further remedies against Karen and the other parties for violations of a protective order or revealing personal information that were never proven to have occurred in the first place. Karen doesn't have time to file that motion for reconsideration because Judge Gildea, in the footnote, sneakily says if Karen's going to file that motion for reconsideration, she has to do it pursuant to Rule 9A, which requires giving the other party 10 days time to respond, which will be way after July 9th. And you can't appeal as far as I know, there's some exceptions, you can't appeal pre-trial civil orders. You can't. Wow. I didn't believe it. If I didn't see it with my own eyes, I wouldn't believe it. If I didn't follow the docket meticulously, it's why I didn't believe it with Judge Cannoni. I didn't follow it close enough, and I was a little propagandized by the, various organs in the apparatus of this case, in the orbit of this case. Various apparati. I think if I had watched that case, the criminal case, both of them, as closely as I am this civil case, with a discerning eye towards Judge Cannoni, I would have more questions. But I swear to you, if you came to me as an independent arbiter and presented me this order and made the argument that I just made to you on this stream, I would say to you, you're out of your mind. And if you came back to me and said, no, listen, I know the rules of civil procedure, and you used the terms that made me realize you knew what you were talking about, I would say, fine, I will look at the docket. But I refuse to believe you. That just is not, you're biased. You either hate somebody involved in this, or you really want to see somebody win, or you don't like the judge, or the clerk looked at you wrong someday. You're lying to me. I don't believe you. If I didn't see it with my own eyes, I wouldn't believe it. I really wouldn't. It's got to be infuriating, too, because the lawyers can't say anything. I bet some of them are watching. How are you doing? You going to watch the World Cup later today? You got to take your mind off it. Remember, I got a great piece of advice from a very smart man one time. And he said, when you're riled up about something, you're going to have a lot of ideas. Don't write anything on paper until you sleep on it. Ideally, 24 hours. If you don't have 24 hours, at least sleep. Because whatever you wake up thinking is likely either the right answer, the best answer, or leading you in that direction. Don't do anything while you're mad. Especially when there could be serious consequences. Just don't do anything until you sleep. Throw all your ideas out there. Yell at the wall. Go run around. Watch the World Cup. Get mad at Belgium. Whatever you want to do. Don't do anything right now. Don't put anything on paper that can't be retracted later. And for the love of God, don't make any public statements. Don't do anything. And they all know that. This is tough crisis PR, though, I'll tell you. This is the toughest situation. Listen to me. Part of the art of being prominent, fame is a degraded form of influence, you must understand. It sucks to be famous, right? Do you know the names of... Do you know the name of the couple who own the Empire State Building? I do. One man owns it. Well, the daughter's got oil money too. But, I don't know nothing about nothing. Are their names in the Forbes list? No. Because fame is a degraded form of wealth and power. Okay? The real power, their names are in the newspaper twice. Once when they're born, once when they die. Maybe a wedding announcement. Because they don't want you to know who they are walking around. So, my point with that is it's such an untenable situation to have to do crisis PR because in this situation, because crisis PR, the whole art form of it is you have to speak within the confines of the rules when you're a lawyer, and then also like in a way that the public will understand and in a way that the press will eat up, and they can do none of those right now. They're muzzled without a gag order, basically. They're facing a judge who is not just hostile, but is bag jobbing them with procedure, with rulings in the courtroom, with the factual record, and they have very limited recourse procedurally because of the civil context. So the move that they make, it's a very narrow window of options for them right now. They need a lot of help, and they can't ask for it either. They need an answer more than anything else. There is so much in this ruling. And I don't mean like, oh, you got to read like 45 cases. No. This is a crazy court order. I don't think as long as I spend time looking at court documents across the states and in federal courts, I will ever see anything like this again. I mean, some of Judge Rao's opinions, with all respect to Judge Rao, some of the opinions that come out of the Fifth Circuit, dude, I'm just like, where are you coming from with this one? But it's still like so cogent. Like, I just have to bow out of reverence. It's also like reading the Ninth Circuit. Sometimes you read the Ninth Circuit, you're like, what the hell are you people doing in California? Like, what the hell is going on out there? But at least it's like, it's more like ideological. This feels personal. But it doesn't. Like, there hasn't been anything that's happened for it to be this personal. It feels worse than personal. It feels like cornering, like kettling the Karen Reed defense. Which makes me wonder who gave the marching order and why. And this is bigger than just one lawsuit, because the trial court assigned the other case that was down in Barnstable up into Plymouth in front of Judge Gildea. But they haven't done that for the lawsuit Karen filed out in Bristol. Wonder if the trial court... Listen, here's an insight. If the trial court never moves Karen's case that she filed in Bristol against the state policing, the Canton police, to Plymouth in front of Judge Gildea, they lost confidence in him. Did he ask for this case? Oh. This opens up a lot of uncomfortable questions that I don't really know if I want the answers to. Alright, let's look at... We got, what, about 50 minutes? Thank you for staying with me, by the way. This towel news. 2 hours. We've been going for 2 hours. It took me 2 hours to analyze 4 paragraphs. What? Oh. Okay, well, my name is Grant Smith Ellis. I need to be honest with you. I thought that was about 3 minutes. So, I was like, oh yeah, I might be like, giving him a lot of information in 3 minutes. That was 2 hours? Whoa. We didn't even do what I want to do either. I'm a little blown away. That was 4 paragraphs. It took me 2 hours. I guess it goes to show how layered it is. Let's take a breather. How are you all doing? Ms. Holmes, that's true. She's down in Brockton, but I think she's what's called, Judge Canoni is the regional administrative justice for this court. Yeah, we're weird in Massachusetts. Oh, by the way, every 2 hours, my dear friends try to remind me, if you want to help support this stream, thank you for all your wonderful memberships, and thank you for all the wonderful stars. I'm sorry if I missed any super chats. I was in my towel flow state zone, apparently. There's ways to support this channel. It's a one-man operation. I can only talk for so long because I overused my voice a little bit. It feels better when I don't talk and, whatever. But it's healing. I talked a lot during the war. A lot of adrenaline. That was tough. If you want to support this channel, though, if you find this information interesting, and trust me, we're going to read Rule 9D to find out more, you can donate to support the Towel channel. Oh, Danielle asked what I think will happen with Turtle Boy's case. I'll answer that as I take a little 2-second break. But yeah, the ways you can support, if you don't have a Cash App, actually, that's a great way to support. You can click that little link in the chat that Bunny, Super Towel Mom Bunny, and Kofi and Bo sent. You can, if you don't have a Cash App and you create one, you can get $5 if you send $5 to anyone. And then I get $30, but you got to click the link in the chat. If you do have a Cash App or other apps like Venmo or PayPal, it's been 2 hours, so I have to do a donation read because it helps subsidize. I don't want the burden of keeping Towel alive to fall on any one person. But yeah, all the streaming software I pay for, and then the hosting, and then various other things. It's a lot. And then, I try to live. But yeah, if you want to help keep Towel alive, send Towel some dinner. I want to get pizza, I think, tonight. I'm feeling like cheese and bread because I had a surgery on my tooth today. So the doctor said, oh, she was a great doctor. She was a dentist, but a special kind of dentist, like the one that wears like the very special glasses that like zoom really in. I don't know what it's called, like more like a dental surgeon, but she is a doctor too. So anyway, they called her doctor. So anyway, there were like 3 nurses. It was a lot. But anyway, my point is, I also did this after dental surgery where I was a little bit out of it. They definitely put needles in Towel without his permission. There's a Cash App, # Grant Smith Ellis. There's a Venmo at Grant-E1. There's a PayPal, paypal.me/Grant Ellis. God bless all of you who help support Towel channel. And by the way, that's also why if it sounds a little bit like spacey, not as normal, I had dental surgery. So, I did like relatively good today for that, but they also stuck needles in me, and I don't like needles. So I reserve the right to be mad and a little spacey because they stuck needles in me, and I was mad. But then the dentist said I did a really good job. I didn't faint today. That was great. It was a bit of a big needle. She was like, okay, we might not have to use a needle. I was so happy. And then she was like, oh, we have to use a needle. And then I was like, is it a little needle? She was like, well, and then it was not. I was like, she just kept going. She was going to do it. She was insistent. We got it done. I didn't faint. I was proud of myself. I faint 8 out of 10 times. So, anyway, if you want to get me some Towel dinner tonight, that would be great. You don't have to. I'll make it work. God bless all of you. I'm a Towel. And if I haven't seen any of your donations that came in, I promise I will go through them after the stream, and I'll click the little heart button, try to leave comments on all of them, but my phone doesn't always send the alerts. I don't know why. I'll look more into it. Could be because the data's not active when it's like not on, or when I have it in sleep mode. I don't know. God bless all of you, though. I'm going to read the most operative part of this now, and we're going to find out whether Judge Gildea is right about whether these motions did not comply with Superior Court Rule 9D. Now, you might be saying to yourself, Grant, You did not shepherdize Superior Court Rule 9D. Yes, I did. Yes, I did. Oh, Danielle, thank you so much for becoming a Towel member. Let me answer that question before I forget. Turtle Boys cases. Here's my opinion. In September 2022, journalist Aidan Turtleboy Carney wrote a story. You should read it. It's about Sandra Birchmore, a young woman tragically killed in February 1st of 2021. Matthew Farwell, the former Stoughton cop, will go on trial for her death in federal court in August of 2026. Sandra Birchmore's death was investigated by Brian Tully's State Police Unit. Brian Tully was the detective lieutenant assigned to Michael Morrissey, the Norfolk DA's State Police Detective Unit. Now, that unit had 4 divisions, but under Tully was the first officer or executive officer, a man by the name of John Fanning. Remember that name. He comes up a lot. A lot. And remember the name Colleen Crawford, too, with 1 L. She worked for the Norfolk DA as like a video editor, but for some reason in 2022 owned a company with none other than John Fanning. Secretary of State records confirm it. So, a tech company of some kind. So, John Fanning was the man who somehow cleared Matthew Farwell, despite a litany of evidence, for Sandra Birchmore's death. Third in command, and John Fanning used to work as a cop in Stoughton. And so did Yuri Buchanan, who was the third in command. Yuri blocked me on Twitter. Yuri. I've never met the man, and he blocked me. And I like Ukraine. You don't understand. Have you ever seen my coverage of Ukraine? I don't like Putin. I think he's a damn commie. I'm a very vociferous supporter of Ukraine. And Yuri Buchanan blocked me on X. I was all offended. I was mad. So anyway, Yuri Buchanan was the sergeant. And him and Proctor used to go to this gym in Canton. It's called Home Base. Their friend, Kevin Foley, ran it. And interestingly, keep this in mind too, Proctor, who was a line detective under Tully, Fanning, and Buchanan's command, Proctor was friends with this guy, Kevin Foley. And he was a Canton cop back in like 2013, excuse me, correction. And Kevin Foley gets busted for apparently, according to a report in the Brockton Enterprise, that did have a picture that looked awfully like him. And it listed a Canton address, now that I think about it. Kevin Foley got arrested down in Brockton in a sex for hire sting. And about 4 months later, Kevin Foley, at his gym in Canton, is hosting a fundraiser with Canton cop Kevin Albert for, remember, this is Michael Proctor's friend, in his group chat, is hosting a fundraiser at his gym that Michael Proctor and Yuri Buchanan would later go to. For who? John O'Keefe's then recently double orphan niece and nephew. John's sister died in November of 2013. His brother-in-law died in January of 2014, January 12th, 2014, I believe. And then this guy, who knows Michael Proctor, in 2014, is hosting a fundraiser for John O'Keefe's niece and nephew when they're babies, with Kevin Albert, the Canton cop who investigated Sandra Birchmore's death and the John O'Keefe case. at least for a little bit. That's interesting. Keep that in mind, too. All right. So flash forward to September, and we're going to flash backwards and forwards. Keep all these names in mind, all the troopers. Remember, Brian Tully, John Fanning, Yuri Buchanan, Michael Proctor. There's some other names you got to know. Nick Garino, Matt Duane comes up a little bit. DeChico comes up a little bit, but they're kind of peripheral players. You got to think about the command structure. Now, here's where it gets interesting. I don't think Aiden knows this yet, but he sealed his fate long before he met Karen Reed, in my opinion. What got Aiden Carney targeted with criminal charges that I believe are manufactured and illegitimate, just my opinion, by the Norfolk County DA and the state police unit was not the Karen Reed case. Oh, they were coming for him long before then, in my opinion. It was probably his prior state police reporting a little bit, but more so than anything else, his September 2022 article about Sandra Birchmore and Tiffany Overstreet. Why do I say that? Well, Aiden did some really good journalism about Tiffany Overstreet, but I don't know how deep he actually went, because it's not obvious on the surface what actually happened. It's only through the benefit of hindsight can you understand what happened to Tiffany Overstreet, and also why Aiden writing about it he may not have even realized this, but it got him targeted just like Karen got targeted. What he didn't realize, I don't think Karen realized this either, is what Tiffany Overstreet and that case will teach you is that the Sandra Birchmore approach that Karen was worried happening to her between February of 2022 and June of 2022 is not what they do to people in the public eye. They don't. They do you a much different way. If it's easy, they'll take you out in one fell swoop with some thing you did. Alright? If they got it. If they don't got it, then they're going to infiltrate your life. I promise you. They're going to use intel agents or sheep-dipped state informants who are working private intel with no paper trail to infiltrate your life with no Fourth Amendment protections for you. They're going to steal your shit, and they're going to evidence launder. Sound familiar? Because they're not going to do you like Sandra Birchmore. That's you can't. You know what they do if you put too many eyes on you as a defense against them pulling a Sandra Birchmore on you? Especially if you have a mass movement, dude. Have you ever learned about CONTELAPRO? I know Karen and Aiden probably weren't thinking they needed to study CONTELAPRO, but yeah, dude, you had a mass movement. Of course you needed to be on guard. Infiltrating mass movements is the bread and butter of the intelligence community. Come on, man. Where do you think various actors learned it from? Now, getting back to Aiden Carney. So, he writes this article, and what you're going to find out is that the Tiffany Overstreet case represents not only putting people in your life, but also using artificial criminal charges to basically keep you under control. Now, the Tiffany Overstreet case differs from what happened to Karen and Aiden because Tiffany Overstreet was probably just known enough locally, but not well known enough nationally or on the state level to warrant the level of operation they ran on Karen and Aiden, which we'll talk about in a second. They will remain the term they for now. So back in, what was it? The fall of 2013, this young woman who I don't know from Adam or Eve, never met her, I don't know who she is. All I've done is research this story. Yeah, we got about 30 minutes. I got time for this. It's very important. Sorry, I burped. I am disabled after all. It happens. So, Tiffany Overstreet, in the fall of 2013, is dating a man named Robert Devine. Now, Robert Devine was married at the time. Robert Devine is also one of the men who worked at the Stoughton Police Department. He was the deputy chief for a while, and the man who set up the Police Explorers program, remember that, comes up again, which was contracted through the Learning for Life Foundation, which you can find in the Epstein files. Indeed. Now, Robert Devine, along with having allegedly abused Sandra Birchmore, also was in a relationship with Tiffany Overstreet. In the summer of 2014, Tiffany Overstreet threatened to reveal Robert Devine to his wife. And I don't think she meant reveal their affair, although that was some of the words she used. Well, there's a very strange confluence of people who then arrive in the town, the billionaire's paradise of Stoughton, Massachusetts, on July 8th into the 9th of 2014. One of them is Jeffrey Epstein. His bank records show him going from Little St. James up to Manchester, to a Dunkies, then a Starbucks, then he probably drove over to Ghislaine Maxwell's house, or was driven, and then he went down to Stoughton. Yeah. Drove down 95, past the split, took the exit at the IKEA, spent $355, $354 at the IKEA, spent $33 at a gas station, disappears for 4 or 5 hours, spends $3 at a Dunkies near 128, heads back on the highway, never leaves more than like maybe a mile from the highway, and is back up in New Hampshire by July 9th. Why do I mention that? Well, because just a few months later, in the fall of 2014, Tiffany Overstreet, wouldn't you know it, catches a litany of state police suspicion leading to what amounted to false criminal charges for investigated by the State Police Detectives Unit assigned to none other than the Norfolk DA, headed by Brian Tully's predecessor, Mark Sir. Oh, let me pause. It's all about Winter White. Says, hey, Grant, what's your Venmo name? Oh, you're so kind. It's, God bless you, all about Winter White. God bless you. It is at Grant-E1. You'll see a picture of an Elmo. That's my dear friend Elmo. Well, it's not him. It's a statue that I like to keep in honor of him. So, Tiffany Overstreet catches these criminal charges for violating an RO that Robert Devine gets against her and then tells her is not active. Now tell me, how often do the State Police Detectives Unit do 7 subpoenas on fake accounts that weren't even Tiffany Overstreet's, it turns out, to arrest and charge someone with an RO violation? We're back. Does that sound normal to you? Brian Tully's future State Police Unit, run at the time by Mark Sir, this unit doing those kind of trumped up criminal charges to help Robert Devine in 2014 to shut up Tiffany Overstreet. Charges that were dropped in May of 2015, by the way, or March, that spring. Certainly kept Tiffany Overstreet in line, didn't it? Yeah. So I guess what Karen knew was the risk of being done like Sandra Birchmore. What she didn't know is that they weren't only going to do her like Tiffany Overstreet. Oh, they had a special Karen Reed package for her, and Aiden too. And he didn't even see it coming. He walked right into it. because he didn't know how explosive the Tiffany... If you just look at the Tiffany Overstreet case, it's big. It touches on a lot of the Birchmore players. You see Divine. But if you really look into it, it's a blueprint for what they did to Karen and Aiden. Yep. That was great what you said about Kate Peter. Yeah. So, a lot of these people, I think sheep-dipped is a good word. Okay. They either are useful to cops or were useful to cops in different ways. And I want to continue with the story against Aiden. So, but let me... Kate Peter does play a role in that. So, think about the spring of 2023. You got Aiden Carney, the journalist, who has written about an explosive, earth-shattering story in September of 2022 and doesn't know it. I mean, literally, it touches everything, including Karen's case and Birchmore. He's got the Dick Lair, eat your heart out. Aiden Carney has just exposed Leah Genduso, eat your heart out. Shout out the bathtub. Leah, listen. Did you really think you were going to pull the wool over Jolene's eyes? Comedians are not stupid. They're brilliant. Come on, bathtub. Chill. You know what I'm saying? Bathtub's going to get so made. Oh, wait till you look into the whole bathtub thing. Tully's lawyer's got an indirect connection to her, too. It's wild. Shout out bathtub. Listen, I'm not into bathtubs, bro. What the fuck do you want? I like showers, all right? It's different strokes for different folks. No pun intended. Anyway, so, my point is, 2014, all right? You got this situation where, and jumping forward to 2022, from 2014 to 2021, you got this situation where this unit, this state police unit, is intertwined with cover-ups, in my opinion, of Sandra Birchmore's murder. A cover-up. You got a situation where they used artificial criminal charges to shut up Tiffany Overstreet, okay? And then, by February of 2022, Karen Reed's on their radar. Do you think maybe they thought, just wondering, do you think maybe the state police thought, oh, damn it, Turtle Boy is going to figure out about this case? Damn it! Do you think maybe, just maybe, two very specific people in the spring of 2023, Jen Altman and Natalie the German, Natalie Wiebeke Berkshire, sorry, Natalie, it is what it is, bro. I mean, come on, listen, you know my mom, you know what they did, okay? So, I call Brian Tully a little bald man. I'm being very gentle in terms, and I'm not talking about what anyone looks like in terms of Natalie or anything like that, but in terms of the things I could say, Miss Wiebeke Berkshire, I'm being relatively reserved, because game recognized game. They say the farming instruments do too, but I don't really understand that saying. So anyway, 30 more minutes, or we get that. In the spring of 2023. Oh, you all have a great time watching Melanie Little. Send my love to the cupcakes. I'm only going for 30 more minutes. But listen, I will say, normally I would tell you, go right over, etc. You probably want to hear the end of this story. It gets really good. All about Winter, and I'm only going for 30 more minutes too. All about Winter asks, I want to know when you made the turnaround and why. You are doing great work. Congratulations on your graduation. I will absolutely get there. Let me remind myself to answer that question. Where can I do this? How do I remind myself? Oh, I should probably open a notepad. Let me just do it on my phone. Okay. Answer Winter's question about what opened your eyes. Okay. Getting back to the timeline. So the two people that introduced Aiden Carney and Karen Reed, Jen Altman and Natalie the German, both of them, Natalie within months, Jen Altman took a little longer, became vociferously pro-state police and frankly have far more close connections to Kate Peter than anyone should have. All right? Kate Peter is one of these PIs, used to work for Marty Kraft, who knew John O'Keefe. Marty Kraft, former Boston cop. His firm closes, then Brian Albert opens a PI firm. Marty Kraft was the guy who was watching Karen Reed when she went to Tom Beatty's house in like February of 2022. I think Jen McCabe might have hired him, etc., etc., etc. Kate Peter was the woman who, used to work for Aiden, became a disaffected former staffer. And then, in the intelligence world, when you're looking for people to bring on, mental instability, disaffected former staffer, love of money, and ideology are really good ways to recruit someone. I don't know what I'm talking about, though. Or I don't know what you're talking about. Who are you all? Anyway, so my point is, spring of 2023 into the summer of 2023, Aiden and Karen are linked up, but I think the reason that they're linked up, neither of them realize it. I've always said that the difference between boxing and wrestling is that in pro wrestling, both people know it's a work. Okay? Both people know the outcome. In boxing, think Ali Liston 2 up in Kennebunkport, Maine, I think it was, or Lewiston, Maine. Ali did not know it was a work. Only Liston knew it was a work. Okay? His job was just to take the fall. Ali was pissed. Alright? Think about it that way. Okay? Neither Karen nor Aiden knew it was a work. They were being worked. Like, if you think about, and I don't mean this, I mean this very positively, Aiden has a lot of superpowers, okay? But what you also get with Aiden is a very big movement, okay, that Kate Peter knows really well. And you can be damn sure she's had people in there in his movement in all his places since him and Kate split in 2019, because Kate's, like, in my opinion, just a lunatic. All she does is think about Aiden Carney. I said if there was a modern Hey Arnold, Kate Peter would be Helga building a gum statue out of this man. She's secretly in love with him, I think, but she just can't stop thinking about him. Okay, she bullies him because she secretly loves him. All right, that's my opinion. Kate, she's not his type, bro. I mean, he's got a type. She's not it. I'm sure, like, I'm going to stop there. Anyway. So, but you have to understand how dangerous this woman is. Like Kate Peter, the most dangerous thing in the world is an obsessive person with no morals who only cares about themselves and money and voodoo dolls and status and access. That is a very dangerous person. They're very dangerous, okay? They may seem stupid. They may seem ridiculous. They may come off as just strange, okay? Which fits her perfectly. But behind the scenes, they're running Discord servers for witnesses. They're talking to the state police. They're coordinating calls. You don't understand. They're documenting all these shows. They're having Biff, whatever his name is, store all the copies. They're backing it up in triplicate in terms of Aiden. Then they're trying to get it to the prosecutors. Why? Because if you look at the Hybel test for a state agent, as long as you don't directly take orders, basically it's a 3-part test, so I suppose you could get around this on the totality. As long as you don't take orders, and there's no proof of you taking orders, the Fourth Amendment doesn't apply to a private actor just going out there. And for example, let's continue. So right after Karen and Aiden meet, and you got to remember, Kate's already probably infiltrated Aiden's movement. Karen's movement, okay, I believe, was infiltrated as early as July, if not June, of 2023. Okay, and here's how you trace it. Aiden and Karen, if they were targeted because of what Aiden and Karen both together were going to figure out, independently we're going to figure out, but together we're definitely going to figure out about what this unit had been doing for years. Okay, you target them both. Who did the interviews in June and July of 2023? Kevin Linehan, Sean on the Golf. Okay? Look at some of those other people who did interviews about this case back then. They infiltrated that Free Karen Reed movement from the jump. Okay, but they had special plans. This was well funded, which makes me think it was privately subsidized. Because state police, they're good, but dude, they got other stuff. They have a lot of cases to do. They don't have time to spend years building a customized psychological operation for Karen Reed and Aiden Carney. No, that's private money. It might have been to the benefit of the cops. They might have turned a blind eye and taken some of the intel, but I promise you they didn't pay for it. Therefore, what I think was happening was thus. It was a very you got to be a smart lawyer. It was a lawyer, probably a prosecutor, who figured out, listen, if these private intel firms just get in Aiden and Karen's life, one, you just wind Aiden up and just let him off and just use your moles in his network to cause problems. Then two, let's seed people in Karen's network, and then we don't have to even put in writing explicit instructions. We'll just have these people feed us intel, and we can then use it against Karen, and she won't be able to raise a Fourth Amendment objection. And Aiden. Okay, so that's where this starts. Okay, because remember, Aiden doesn't catch criminal charges for this until the fall of 2023. But the plan to get him started way earlier. Okay, they were baiting him and Karen, and they were planting people in their orbit to spy on them to produce information to use against them in criminal and civil proceedings. When did one of those lawyers for the Ham defendants first show up in Norfolk Superior Court? If you answered May of 2023, you win the pony. Now, let's think a little deeper here. So you got Sean on the Gulf, okay? You got Jen Coffindaffer. Have you ever looked into Jen Coffindaffer's 6 bosses? You should. You might say, Grant, where does this go? Grant, what did you do? I didn't do anything. I'm a towel. All right? Now, listen to me. There's only so many times that I can don my Paul Revere towel hat and warn that the redcoats are coming. And then I think you're a fucking redcoat or a commie. All right? So anyway, if you take a look at Jen Coffindaffer's 6 bosses, you're going to find one of them who used to be on a Navy dive team. Now, you might say, Grant, you did not pull the Navy dive team like records from the public internet, and you did not. Yes, I did. Yes, I did. Now, let me tell you why. All right, because I didn't trust her. All right, she was too close to Kate Peter, so I started digging. Oh, yeah. Are you telling me that I found a second-degree connection between one of Jen Coffindaffer's 6 bosses and Sean on the Gulf? You damn right I did. You damn right I did. It's my country. Go over to the UK if you want to pressure criminal defendants to plead guilty before trial by infiltrating their lives. Do it in other countries. It's America. So anyway, starting in about the summer of 2023, they infiltrated Karen and Aiden's lives and their movements. There are people who are, although mostly the D team, still around today who since 2023 have either been faking support for Karen or Aiden or some combination of the both. Okay? And with Aiden, it goes back way further. Kate's had people in his orbit forever. I don't know them all. I didn't mean to mole hunt. It's kind of, I don't know, I just go where the truth takes me. And she's got a lot of moles around him. And he's got to be careful. I've been trying to, say as much as I can over stream. You got to be careful. Right? It's called counter intel. OPSEC, operational security. Now, what happened was, in my opinion, these people that got in Karen and Aiden's orbit, especially around the fall of 2023, if you really want to put this together, I'm praying for guidance at this moment. If you really want to put this together, look at Turtle Boy's October 2023 Halloween party. Furthermore, look at the people, in particular certain women, who started showing up right after Turtle Boy was charged in Stoughton District Court in September, October of 2023. Not when his indictments were bound over, the first 16, on December 20th of 2023, but when he was first arrested. Think about it. Think about it. Huh. I wonder if the girl who got closest to Aiden got the most money. Whoops, did I say that? Must have been a good fucking gig. Shit. What am I talking about? I have no idea. I don't know what you're talking about. Now listen. Now listen. Now listen. Now listen. Now listen. I think I'm making my point. Well, let's say Aiden had a type. And let's say you knew what that type was. All right. You don't know who he's going to pick. Good luck, girls. See who wins. Certainly would explain some of the rivalry, I'll tell you that. And some of the odd, language used between some of those people. Very odd. Very specific and odd language. Like they've known each other for decades. But maybe by other names. I don't know. Diamond. Some random name. What the hell? What am I talking? I don't know what you're talking about. Anyway, so, I also think they weren't all, dancers or whatever. I think some of them were, and I need to be clear, there's a difference between a madam and a dancer, using the term liberally. And there's a difference between a patron of those services, including women, and a madam and a dancer, speaking liberally. I know, I can't even believe this, but there's at least one madam, okay? But I'm not saying, no. Ugh, makes me all mad. There's at least one madam. Makes me really mad. There is at least one girl who I think rose up the ranks because of this operation, and then started treating the other girls like they were less than her. Okay? And then I think these people, okay, get put, it's like no-show jobs. I think they get put into jobs and paid, but they actually do other work. You see what I'm saying? So it looks like they do one thing, so they can actually do another thing. Does that make sense? Mm-hmm. It would explain why they have a lot of fucking free time. Well, they're either stay-at-home, moms, or they're working a job that allows them to, quote, work another job, which is, in fact, how a lot of intelligence work is done. You think a lot of financial analysts are financial analysts? Are you out of your mind? Anyway, so my point is, you got to think long and hard about what happened between when Aiden got criminally charged in October of 2023, and then, the superseding indictments that were then null prossed, and then, one was null. There were three. It was 16 indictments, then 3 more charges, then 1 null pros, then 2 more indictments, then 2 more indictments, and then 2 more null process, and then 6 dismissals. So we're down to 12 cases that Aiden has. Okay? 12 charges. 2 involve the window shop incident, which, by the way, let's talk a little bit about the window shop incident. I'm only going until the start of the game. You got me for 10 more minutes. All right. From the fall of 2023 till, I don't know, probably, oh, Jesus Christ. the fall of 2025, maybe even still till now, it's kind of fleeting right now, though. There was a very active effort. Aiden was the primary target of this. You must understand. Oh, BB Egan sent 5 gift memberships to Scott. Oh, that's great, Scott. God bless you. And to Weird BBM and Classic Clippy and Sharam. Oh, that's great. And Samantha Gluck. God bless all of you. Thank you so much for your support. Now, I think there were different plans for Aiden and Karen. Karen can't be infiltrated that way, and she wasn't. They must have figured out she wasn't going to let people close to her. What Karen did was, what they did for Karen was infiltrate her movement. Okay? They had spies in her movement who, some got close, but they didn't do her romantically. She must be like too smart for that, which I agree, she probably is. The thing they did to Aiden, though, was, I think they used women, okay, and some of his supporters who weren't really his supporters. They got around him, and then they did 2 things. It was very complex. They must have had a lot of meetings about this shit. One, they put him into situations where they could wind him up. They didn't know what he would do, but they knew he would do something, and then they would use that to get him, all right? Because I always remember Sean on the Golf didn't like Karen, but because he leaked her messages to me in February of 2024. He was the first one to ever leak her text, Sean on the Golf. He didn't like her, but he hated Aiden. Hated him with a passion, like from the jump, and I could never figure out why. And it wasn't because of that weird falling out they have. No, he hated this man from the jump, and he never liked Karen. Actually, the first thing Sean on the Golf ever leaked to me in February of 2024 was a message trying to divide Aiden and Karen, now that I think about it. Huh. That's interesting. I never really thought about it that way. So anyway, this situation keeps developing over the spring of 2024 into like the whole 2025 year. And it must have been a lucrative op. Because you got to remember, Kate Peter, like on the first time she met me, like brought me to a Chick-fil-A parking lot for a meeting. And then in the middle of the meeting got an envelope full of cash from a woman in a white Toyota Corolla that Christy Citroni, due to a stupid modified limited hangout because she's too cocky for her own good, revealed was one of like the Albert's sister, the Julie or Lisa Crisello's like sister, sending the money to Kate, which Kate claimed was to reimburse people for expenses, which she never did. And it was clearly like her just showing me what was on offer, in my opinion. Okay, that makes a lot of sense now, doesn't it? Like, I turned that shit down. No, bro. You must understand. Like, if I believe something, it's because I believe it. You couldn't pay me if you wanted to. You can donate to support me, God bless you, but, like, you're not bribing me. Are you out of your mind? I'm also autistic, so hell if I even knew what she was doing. I just wanted to eat Chick-fil-A. Anyway, now that I think about it, she actually brought me over to Lindsay's the first time. I wonder what that look in her eye was, now that I think about it. She would never leave a situation she couldn't control. Kate Peter. I never thought about it that way. Anyway, okay, so, moving on in this story, Kate Peter's sort of involved in all of this. And then, as the people get closer and closer to Aiden, he starts catching like more and more weird charges. The pizza shop incident is a very good example of this. I think we're going to find out a lot more about this. And hindsight has been 2020. We've seen a lot of these people kind of reveal themselves to have been not quite who they were. A really good example of this, and this should have tipped people off right away. The guy who runs a parody account of me on Twitter, he line sat for Aiden one time, and he was fangirling Aiden so hard, I was worried he was going to break him. All right? This guy, he's kind of like a little minion, not the guy in the minion costume. He was a nice man. I hope he's doing well. He had some health problems. This is a different guy. This is kind of like a portly, like odd looking man with like a lot of stubble. He looks like the kind of guy who, I don't know how to put this gently, like plays a lot of World of Warcraft. So anyway, this guy is like, I remember when he met Aiden the first time. I have the video of it. I filmed it. He was like, oh, Aiden, I'm so glad to meet you. Like, I'm your biggest fan. Like, my name is Stan. His name wasn't actually Stan, but he was riding Aiden hard. And Aiden was like, yeah, good to meet you, bro. Thanks for sitting in line. Like, I hope you enjoyed the donuts. Meanwhile, I'm at the time just thinking, like, oh, screw that guy. Like, he's just like a obsequious, like, fan. Hell no. Dude, this guy now calls for Aiden to be jailed on the regular. This was one of his line sitters, which means he was in his internal volunteer group. He was a spy. Turns out the dude's got like multiple previous federal convictions for hacking. Yeah. Moved out of Massachusetts after he did his bid too. Up to New Hampshire, I think. Interesting. This case against Aiden hinges on 3 important cases: Odell, DiBenedetto, and McCarthy. If it makes it to trial, I can't even imagine what that would be like. I guess it would be a proper swan song for Michael Morrissey. But the legitimacy of the case was compromised because the state police did something that is completely inappropriate, which is either tacitly condone or enable, or worse, direct, a private intelligence operation that infiltrated Karen Reed's life and her movement, and Aiden Carney's life and his movement, and tried to launder the evidence for use in criminal and civil proceedings in violation of the Fourth Amendment. Well, you don't really have a Fourth Amendment right in the civil context anyway, but the point is, some of the stuff that was done to Aiden was dirty. Dude, they must have, like, whoever bankrolled this hates him. Hates him, like, to the point where they would write a letter to the government about him, just him, and misspell his name. Like, they hate him that much. You gotta have millions to do this, too. You gotta be able to hire people, pay them off, keep them quiet, run what is in essence an alternate reality game in the real world, and then get these operatives to get evidence. You have to use like sex, love, lies. You have to be willing to do anything, and you have to hate that target, because basically what you're doing is constructing a personalized plan to infiltrate their lives, drive them crazy, and then get them to make bad decisions so they're forced into a guilty plea before trial. Do you understand? Now? That's exactly what happened to both Karen and Aiden. Karen went through her, whatever you want to call that, when you make it to trial and win. You don't fall victim to the pressure to plea, and you win the trial. Alright. Now, I think what Karen's probably waiting for is to see if Aiden can pull it off, too. He's got a good legal team. Better or smart. So that's where we're at. The question is, how much of that evidence was compromised? How much is Aiden going to be able to get on the record? Judge Doolin's more favorable, but he's in front of Judge Belzeos now. How much of the third-party sort of Discord servers and the coordination and the spoliated evidence and the Fourth Amendment violations, like how much can he get in? Will it be enough to sustain a motion to dismiss? Will Morrissey null pros? Morrissey clearly does. And remember, Cosgrove, who's prosecuting, answers to Morrissey. Morrissey is, quote, recused, but under the statute, the special prosecutor answers to the DA. Okay? Yes, Bailey Love, I will be there. Aiden has a motion to dismiss hearing on, I think, July 20th or so, July 26th, somewhere in there. I'll be there to cover that. And that's frankly what this is all about. I think Karen might have backed off a little bit in the criminal case because it doesn't make sense to me why some of the jurors were rep by the same PR firm that David Traub and Precipio or whatever his name is, the state police spokesperson, both went to work for in December of 2024. Traub was the Norfolk DA spokesman. Doesn't make sense that Reagan Communications then repped Paula Prado and the foreman and the guy who went on TMZ, the juror. It doesn't make sense. And the only way it makes sense is if Morrissey and Karen's team made a deal, because Morrissey couldn't plea Karen out because John's family would have lost it. So Morrissey made a deal where the plea was the trial. I don't know. If I were them, I'd no press Aiden's cases. You're crazy to take this to trial. If Kate Peter gets called as a defense, first of all, if I were Aiden, Kate Peter would be on that defense witness list. I'd call her. I've seen her testify. Okay? I'd call her. Second of all, you're risking. Everything's bad. You could kind of contain ProctorGate by blaming it on this unit, but it's going to spiral out of control, especially with Farwell's trial. You are out of your mind to try him. But they might be so pot committed that they do it anyway. All right? I think they're out of their mind, but they might be that pot committed. However, the best arguments here are that the whole process was compromised. Ken Mello's grand jury in the fall of 2023 was compromised by Kate Peter and Brian Tully, in my opinion. The subsequent grand juries were compromised. Why did Greg Connor's name appear on a fake subpoena for a grand jury that I'm sure, although it met eventually, did not meet on December 27, 2026? 2023, correction. There's just, you can't, the whole point is to get these defendants to plead guilty before trial. That's the playbook. With a customized plan for them to psychologically pressure them. And I think the plan failed on Aiden. I think they're letting up. There's mostly just bitterness now, I notice, around him. A lot of these operatives are just bitter. They're just mad. They were getting paid well. I think some of them got cars. I think some of them got straight cash. A lot of it was untraceable. Now that I say it, Kate told me she got the money in cash because there would be no record of it. Thought that was weird. I was like, well, if they're just donating to you, you could get it on Venmo. They wouldn't have to drive over. Me and my simple mind. Alright, my name's Grant Smith Ellis. I want to go watch this World Cup game. Oh, I had one more question to answer. Someone, I think it was Winter, asked me, what made me change my mind? What was the first moment? Well, Sandra Birchmore's case had me on guard. But if you want to know the actual moment that did Michael Morrissey and his men in, you want to know? I'll tell you. It's a good end of the stream treat. Should I get Pete Bunny Towel for this? Francine loves her friend Pete Bunny Towel. In 2024, maybe 2023, late 2023, early 2024, little towel was being a little towel. And there was a sentence said that, although at the time I didn't understand, completely changed how I approached these cases. And the sentence was, it's not Michael Morrissey, it's the people around him. I said, well, and this was not someone involved in the case. I'm not even going into details, but We'll call it an amalgamation. I said, well, shit. If this person, this amalgamation is saying this, well, shit. I gotta really think about what I'm doing. Like, I have to, like, why am I actually going so hard for these guys? Because then I knew who the problem was. I mean, why am I defending this unit? Like, I really care about what happened to John O'Keefe, and I want his family to get answers. That means a lot to me. But why do I give a shit about Michael Proctor, Brian Tully, Yuri Buchanan, Nick Guarino, or any of them? I have a little sympathy for Guarino. But why? Because I'm not sure that drunk driver crash that he was targeted by was an accident. But like, why? Why was I going so hard for them? I didn't know them. And they clearly did bad stuff with Birchmore. So then I was like, well, shit. I got to start being way more critical of this unit. And then I found out really what they were up to. I saw behind the curtain. And then it all started adding up. Like what Tully was doing, how he was moving, what Fanning was doing, what, like all these, like it all lined up. And then I was like, well, shit. Not only are these guys like dangerous, and this was before ProctorGate. We're talking like fall of 2025 now. I was like, well, shit. These guys are dangerous. Rosemary Scapiccio is like losing her mind, saying that like Michael Proctor is the most dangerous human being like on the face of the planet. And this was while all the stuff was impounded. And she was saying this in court, but we didn't really know. And I was like, well, oh shit. And then I was like, well, wait a minute. I saw how Fanning acted in the Birchmore case. I saw how Tully acted in a lot of regards. I saw kind of what happened like with Kate Peter and Ken Mello. I saw like all this like weird stuff. Like, what if it wasn't, let's get this guy, so let's like help each other? What if it's like these people are working towards a bigger end? And then once I looked at it through that lens, I think that's when the Mystery Man footage came out, late 2025, early 2026. Then I was like, well, shit, they pulled the wool over my eyes really, really bad. And they really manipulated me. And I got to now reconstruct this whole thing. And now I'm mad that they took advantage of me. So I'm going to apply that same methodical reasoning without the blinders and look at everything. I already knew most of it, but now I'm really going in. Oh yeah, they made their worst enemy. Absolutely. They shouldn't have lied to me. If you want to read me in on something, at least offer me the opportunity. They couldn't do that though, because they knew I would know immediately it was a cover-up. Cowards. Cowards. So this is the price they pay. Historical serendipity, as it were. But yeah, once I figured out about the Overstreet case, that was right about when I was researching the Epstein files. And then I put together Epstein being in Stoughton and Turtle Boy's September 2022 article about Overstreet and Birchmore. And I was like, fuck, these guys are ruthless. This is straight like military intelligence. This is very impressive. And then I was like, nope, I'm not having it. That's when my rants about you can't do this on domestic soil started. Yeah, it's wild. I wish I had more time. We can hang out tomorrow. I want to go watch this game. Let's give Towel a little bit of time. But yeah, what I know about this, the best I can discern, and I'll leave you with this before we do Tippecanoe, and Tyler too. Shout out Trip of the Bob. It seems that they targeted the kids at a young age. They had a profile, okay? Mostly vulnerable young kids. They would funnel them in to programs that were ostensibly for underserved youth, but or even like people from good homes. And then they would profile them and groom them. And the people went on two paths, boys and girls. Okay, both of them had both paths available, I'm pretty sure. If they were groomed and they were rewarded for not stepping out of line, they became cops. Do you understand? So they would perpetuate the system, men and women. If they were not capable, and this is why passing that entrance exam must have been so important to Sandra Birchmore, if they're not capable of becoming cops to stay within the system and be controlled, they get put on another track. That track starts, I believe, with two options. One is escorting and the other is brothels. I'm just going to tell it to you straight because you deserve to know. If you look a certain way, you escort. If you look another way, you go to the brothel. Understand? And let's call it a tier regulation system. You're going to easily move between these two depending on how you perform and how you look and whether you get pregnant. Once you're on that track, you might become a madam if you're lucky. But 98% of the girls and boys on that track are going to work in a restaurant with a room in the back. Maybe in Stoughton, maybe in Dedham, maybe in Boston. What the hell do I know? And you're going to be able to order them from the waitress off the menu. Now that's comparatively rough, but it's not as bad as what happens when they're used up there too. Because then they get passed down to the street pimps. And I promise you, that's even worse. And then once they're down at that level, well, you got them hooked for life through probate and family court, criminal charges if needed. And of course, they can't leave. How are they going to leave the state? They probably have a few kids with a father who's not there. Just have the father, who's probably got his own problems. Maybe you got him off on a few charges so he does what you tell him. Just never consent to them leaving. I'm just speaking generally. This is not a story unique to any one person. It's in the public interest that people learn about how they do these girls and boys. But the women in particular, obviously, get it the worst. And you know how they subsidize it? The pimps, that is. With our tax dollars, they move these girls around. Oh yeah. And they can make their life worse or better based on whether those girls stay silent and how they perform. And we're not having it. Those are my little birdies now. And I don't want to have sex with them. You're going to free them. You hear me? Whoever you are out there. You never know who's watching. I don't know nothing about nothing. I heard a cop out in California got arrested 4 days ago for grooming a girl in the Police Explorers program. Huh. That's weird. Uh-oh. What was the word used in those emails? Whoopsie. Alright. On that note, we will come back. Let's come back tomorrow. I will analyze Rule 9D for you. I promise you that's not the substance of this, whether Karen's lawyers appropriately complied with the scope of Rule 9D. I'm going to guess Judge Gildea liberally interpreted the scope let me, wait, what's the opposite of liberally? Conservatively interpreted the scope, non-liberally. But I'm going to go watch the game now. I'm going to do Tippecanoe and Tyler too. A lot to think about tonight, folks. Not just in the context of this case, but in general. Oh, by the way, if you really benefited from this stream today, I have a request. You can tell your family or your friends or just random people that you have this really nice man that provides information and helps you learn about things, the news, court documents. And he has a request. He would be really happy if you stopped buying prostitutes. It would just make his heart sing. Because there's no way to have that system that does not enable human trafficking. If there's no supply, if there's no demand, there will be no supply. Stop buying prostitutes. Stop it. Tell your family. I know you in chat don't do it. But you go out there. We're going to drain them of their supply. Now, the girls are going to be made. I understand. We got to I'm going to recover Jeffrey Epstein's paintings. It's a lot. It's like $3 billion. And I'm going to find the paintings stolen from the Isabella Stewart Gardner Museum. We'll give all that money to the girls and the boys that were hurt. But for now, stop buying prostitutes. That is your Towel Public Service announcement for the evening. You're not going to hear this. You probably should hear it on more stations. Stop buying prostitutes. Stop it. That's very good, classic Clippy. I'm actually very proud of you. All right, my name's Grant Smith Ellis. I got to do the U.S. presidents, and I'm getting out of here. I'm going to watch a soccer game, and I'm going to try to eat some food, and then I'm going to bed. DD Tames and Buddy Towelbaum and Kofi, all of you, you're great and clumsy clairvoyants. Hashtag Adnan Khashoggi stole Grant's paintings. Grant would like them returned to their rightful owners, the people of the great state of Massachusetts. Thank you for your attention. I'm a tab. All right, Tippecanoe, Tyler 2. I got to do this truncated. I want to go watch the damn game. What's the score? If somebody scored, I'm ending this very quickly. If it's 0-0, meh. Damn it, Belgium already scored. God, I told you Romelu Lukaku is dangerous. It's 1-0 Belgium. All right, all of you, if you like the USA, put on your cheering caps. I told you those commies were going to screw it up by cheering for Belgium. All right, here's Tippecanoe and Tyler 2. President Washington. We like to do the presidents in order to test my mental acuity at the end of the stream. President Washington, President Adams, President Jefferson, President Madison, President Monroe, President Adams Jr., President Jackson, President Van Buren. 9, 10, 11, it's a little hard. It's like William Henry Harrison, then Taylor, then Polk, then 13 is Millard Fillmore. We're not doing the numbers tonight. And then it's Pierce, Buchanan, Lincoln, Johnson, Grant, Rutherford B. Hayes, Garfield, Chester A. Arthur, Cleveland, Harrison, Cleveland, McKinley, Teddy Roosevelt, William Howard Taft, Woodrow Wilson, Harding, Coolidge, Hoover, FDR, Truman, Eisenhower, Kennedy, Johnson, Nixon, Ford, Carter, Reagan, Bush 1, Clinton, Bush 2, Obama, Trump, Biden, Trump. I think I'm basically at all 47 presidents. Glam Massouz the other day got really mad because people on Jeopardy kept getting the question wrong about the presidents, and she tweeted and was like, listen, Grant would nail this. Like, what are we doing? What are we doing here? We got to put Towel on Jeopardy. Damn right, Glam Massouz. Shout out, Glam Massouz. That was a great catch. All right, but yes, so here's the plan. We're going to reconvene tomorrow. All right, I want to go watch the World Cup, and I'm going to reintroduce the people who missed this because inevitably they were waiting to watch the game or doing other fun things like being cupcakes or whatnot. And we're going to start from the Rule 9D analysis. Okay, I'll give a brief synopsis of what you all learned tonight, and then we'll do this Rule 9D analysis. I think you learned a lot tonight, though. And by the way, don't even think for 1 second that I didn't have a case pulled up ready to talk about in reaction to the allowance of adverse summary judgment, Audubon move for reconsideration pursuant to Rule 9D of the Rules of the Superior Court. In her memorandum of decision, the judge had provided the parties with 8 pages of explanation of her ruling. All right? And so we're going to find out exactly how Rule 9D works and the standard for an appropriate motion for reconsideration. Until then, if you learned something tonight, my name is Grant Smith Ellis for Tal News. By the way, youtube.com/@Grant Smith Ellis. It's 8:19 p.m. Eastern on this Monday, July 6, 2020. 26. If you learned something today, if you benefited from today's stream, feel free to pay it forward with a donation to our veterans. By the way, ladies and gentlemen, let me just pull you up this on the screen. Did you know, actually, you know what? You could help Towel out a lot. If you all wouldn't mind, I'm trying to make an effort to help our vets. And normally I would just tell you all, donate to whatever veteran cause or homeless veteran cause or service member cause you can find. But today I actually have a specific request. If you all would be so kind, there is a wonderful charity. It's down in Bristol County. I'm so sorry I forgot to do this earlier. It is down in Bristol County. Would you all mind considering a potential donation? It's a really worthwhile organization. I'm trying to raise $702 for them. I didn't manage to do that. I donated $50, and my friend Kelly Patton donated. She's wonderful. I don't know her, but she's my friend now. She, I think, matched my donation. It's called the Veterans Association of Bristol County. So if you would be so kind, the link is thevabc.org/donate. If you'd like to consider a donation to the Veterans Association of Bristol County, you can see Towel. They're a wonderful nonprofit. They feed our veterans in the Bristol County area in Massachusetts. I was happy to make a donation earlier today, and I hope you'll consider that as but one of the donation options that you do if you're out there trying to help someone, and in particular, our vets today. You're so wonderful, Bunny Towel. Francine, you're here. Hello, my friend, and hello, Clumsy Clairvoyance. Francine, Pete Bunny Towel, so excited to see you. All right, so you may consider a donation to our vets or our homeless vets or service members. There should not be a single homeless vet or service member in this country against their will. If there is, we failed. You can help them today, ladies and gentlemen. Consider a donation to any veterans charity or charity supporting our vets or homeless service members that you can find. You may also consider a donation to an animal shelter run by veterans or that helps our service members or veterans. This is Pete Bunny Towel. He's Francine's friend. She loves him. He loves her. He's not an animal. He's a stuffed Pete Bunny. But anyway, if you want to donate to such an animal shelter, that would be great. If you can't find one, any animal shelter in general is a great way to help our fur friends. If you're in the UK, consider a donation to the Big Issue as well. Great way to help populations experiencing homelessness in the UK. But it doesn't have to be a donation. It can be something as simple as smiling at someone on the street, reaching out to a friend or family member you haven't heard from in a while. Or yes, even giving away 200 tomato plants like Francis Futrell did one time during, and having them designated honorary towels during the outro forevermore. In that way, may the current realpolitik, we pray, continue to change from one centered on preserving, expanding, and demonstrating our power, hint, hint, Judge Gildea, to one centered on preserving, expanding, and demonstrating our capacity to engage in small acts of service and kindness rooted in unconditional love. Therein, living up to our Tal Eudaimonia, or Summum Bonum, our greatest good in the ancient Greek or Latin, respectively, and in turn bring about a new digital epic defined by Aquarius, the water bearer, standing tall and carrying a towel. To all my friends, Danielle and Clumsy and Francine and Kirks and Three Clerk Monty and Towel Mom Bunny and Kofi. Kofi's a dog. Hi, Kofi. You're so wonderful. Have fun watching the soccer, Kofi. Kofi, listen. Towel Mom Bunny's going to get excited. Kofi, you can do this. Will the United States to victory. Now, Kofi, what that means is, Kofi, the men have to kick the ball into the goal. So focus all of your doggy energy on willing the men on the screen to kick the little ball thing into the goal. You know, you chase the ball. No, they have to kick the ball into the goal. You got this, Kofi. America for the win. Kofi is an emoji on our channel, by the way. He's great. Signing off from Towel News, a very tired, very exhausted Towel who underwent dental surgery and still did the stream for you. Hashtag persistent Towel. God bless all of you. God bless Kofi. God bless you in Limonene. So good to see you in Clumsy Clairvoyance. And Francine, my dear friend. And Towel Chat Mom Lynn was here earlier. We had a great day. All of you. I'm so sorry if I missed your name. I appreciate all your support, all your wonderful questions. Spacey118 was here. Silent Dogs was here. We had such a great day. Thank you for being you. God bless all of you. God bless the United States of America. I hope they can win the soccer game tonight in the World Cup. It would be great. God bless you, Marcia. It was so great to hang out with you all, even though this was a baffling ruling. We ended on a high note with talking about donations for our vets and Pete Bunny Towel and his love for Francine. Good night, Towel friends. Thank you for watching. It's 8:24 p.m. Eastern. Signing off for Towel News. It's 2:24 a.m. in South Africa. It's 3:24 a.m. in Tel Aviv, Israel, and it's 3:54 a.m. in Tehran, Iran. The latter three cities would be Tuesday, July 7th, 2026 here in Boston. It's Monday, July 6th, 2026. Good night. God bless you all. Mishi Gama, it's so good to see you. I'm glad I got to say goodbye. And yes, please consider joining the Discord. You can find the link in the chat in the description. Have a great rest of your night. Thank you so much for being you. God bless you all. God bless these United States of America. And tonight, God bless a slightly dazed but still persistent little towel. See you all later. Thank you again.